regarding public input. Public input shall be limited to statements from the public relating to any issues with the jurisdiction of the Chelmsford Zoning Board of Appeals that are not currently the subject of a pending public hearing before the Zoning Board of Appeals. Public comment on any pending public hearing shall only be heard during such public hearings and may be limited to 3 minutes' time. Would anyone like to speak this evening? Seeing none, we're going to move ahead to our first agenda item, an administrative review, Morose Avenue, Cobblestone Place, 40B, comprehensive permit. We have an agreement form endorsement. I don't know if someone's here to speak for the
I
applicant.
don't believe there's anybody here. This is a housekeeping item, standard practice with 40B applications. You haven't had many recently, but the board has signed this form in the past. This will then set the stage for the regulatory agreement to go before the select board and then go on to the state for their endorsement.
Would you have me read the acknowledgement?
No need to read the acknowledgement,
Just sign away.
please.
So everyone will sign it. Do we have the 5 voting members?
Let me look that up real quick.
I'm gonna leave that blank. It's Morose Ave.
Is this the 5 unit? No.
Yeah, six unit, I think.
The 2-story that turned to a 1-story?
Yep.
Yeah.
Yeah, okay.
Makes things
three
difficult
copies
for
to
you.
sign,
I have
and
2
final.
copies and 4 copies of the second page. Oh, no, I'm right.
A lot of paperwork.
Of course.
You vote on that?
I'd noticed them. Pretty sure.
Hold on
Let
just
her
a second.
confirm.
Check and make sure.
I think I did the final.
A little more housekeeping, we'll take care of our getting organized with that. We have a new public hearing, 101 Mill Road, owner 21B Street Development, LLC, manager William L. Harvey III, is requesting a special permit under section 195.5, use regulations A4, in accordance with section 195.13, conversion of dwelling units, to convert a single-family dwelling existing prior to 1938 into a 2-family dwelling and other relief deemed necessary. This property is located in the residential RB district. The hearing is open. We're going to not take a vote or testimony. We do not have a quorum suitable for the project, and we're going to vote to continue this until October 2nd, 2025.
I'll make a motion to continue to October 2nd.
And who can vote on that? Anybody? All?
Everybody.
Okay. I have a motion. Can I get a second?
I second.
Second by Jamie. All in favor? Aye. All opposed? Seeing none? Unanimous? I'll give you a minute.
Sorry, the 40B decision's a little bit different.
Yeah,
I'm just
yeah.
looking to see where it lists the 5, because the signature page is different.
Okay.
What are you trying to determine?
The voting members on the Morose Avenue, who actually voted?
Let me go with the minutes for that day.
I'll check the
Am I
minutes.
on?
Yeah, check the minutes.
Okay, I'll let you wear that. That can be continued. Our next hearing is 28 El Dorado Road. Owner Farouk Karini is requesting the... Karani? Thank you. Farik Korani is requesting an administrative appeal under the zoning bylaw, section 195-2B3, and any relief deemed necessary to overturn the building commissioner, zoning enforcement officer's determination of by right denial per Article 1D4 parking. Separate driveways are not permitted for new ADUs, and issue a finding based on reasonableness test set forth in section 760 CMR 17.033A. The applicant also requests that all filing, abutter notifications, and legal fees associated with this petition be waived. This property is located in the residential RB district, Assessors Parcel ID Map 126, Block 469, Lot 1, and consists of approximately .94 acre. Good evening.
Mr. Chairman, just to give some,
For the record, sir.
Farouk Karani, 28 Eldorado Road.
Thank you.
Mr. Chairman, just to give some very brief context, as the board likely knows, this is the first EDU application that this board has seen. And it's likely the first time the board is seeing or dealing with the ADU bylaw and the ADU issue. So based upon that, we've asked council to join us tonight, kind of walk the board through the uniqueness of the ADU as it's defined by the state, which is a Dover use. So it's unlike many things that the zoning board has dealt with in the past. It's not a special permit, it's not a variance. Farouk is the first applicant. He's been engaged with Town Hall for many, many months. And the final item I'll say is that this will likely be the first of a number of similar applications that will need to go to the zoning board until such time as the planning board decides or chooses to advance any amendments based upon the ZBA experience.
We are, in essence, reviewing the building inspector's decision.
As I understand it, the building inspector denied the by right application based upon the
dual
words in the bylaw. And it is now your job, based upon the applicant's request, to make a determination as to what extent the request for a second dedicated driveway for the ADU is reasonable. And council and the applicant will go into much more detail related to that reasonableness test.
Because we don't have any information of this on the zoning book, correct? This is
What?
all
I'm sorry?
new. Yeah, this is all new law. We won't have anything in the zoning book to refer to.
We have an ADU bylaw, which in many aspects reflects the state ADU bylaw. This provision is essentially a local provision.
This is a town provision.
Yeah, it's essentially a local town
We
provision.
decided at town meeting.
Correct.
Okay.
All right, thank you.
If you'd like to give us a little overview of your point of view on this?
Again, you know, I've stated it in my application. I'm not sure if you guys have fully read it or not, but essentially the state gives all homeowners the by right for attached or detached ADU. I'm applying for a detached ADU with a garage. My lot is, again, if you see this, it's a wide lot. Okay, so the most reasonable way to do this is with a separate driveway. The most unreasonable way to try to make me do it is pave through my front yard to get to the garage. Okay? It's just that simple. And as I've stated in the application, Chelmsford's ADU bylaw, and I told the planning board this when they were drafting it, does not allow for a Dover use reasonableness, calculation, unlike other towns like Natick, et cetera, where they have a ladder of, okay, we'd prefer this, but a driveway is ultimately allowed. So because the building inspector, who's the zoning enforcement officer, is not given permission by the town to determine the reasonableness of a request, that falls now on ZBA. Am I stating it correctly?
Sounds right to me. We could get a little input from the attorney on how this would work.
Yeah, thank you, Mr. Chair. Is this on?
Yes.
Okay, good. So maybe just a little more overview might help the board. So town meeting did adopt a bylaw to address accessory dwelling units. It's now section 195-6.1. And that sets the requirements for allowing ADUs in the town. That bylaw was adopted to bring the town into compliance with the recent changes to state law, which make ADUs of a certain size a by right use wherever single-family homes are allowed in the town. So this bylaw is an attempt to basically meet those standards. However, there are a certain number of black and white requirements in the bylaw, which the town is allowed to put into that bylaw. Some of those are design requirements, some of those are dimensional requirements. One of the requirements here, it's in section D4, is that no additional off-street parking space should be required. An off-street parking space shall have vehicular access to the existing driveway. A separate driveway shall not be permitted for an ADU. That's from the town's bylaw. So what Mr. Ferrani proposed is an ADU on his conforming lot, which has his house on it. And you'll see the plan that he put up there. Everything about that ADU conforms to the town's bylaw except for one thing. It has a separate driveway.
And if I may, in the AG's response to the town
Are you saying the
council
Attorney
committed to
General's
the AG
response?
that this would be a fact-finding and not follow the bylaw strictly.
Jumping ahead a little bit here. So the AG has not reviewed his petition. The AG has looked at the town's bylaw and approved it. It excised a few words, but now it's in effect. So what's different about this from a normal application, normal appeal, is that if a building permit application for an ADU does not comply with the black and white town bylaw, ordinarily that would simply be a no, and you could ask for a variance or a special permit. But this particular use is now a protected use, like churches, like schools, like child care centers. They're in a separate section of the State Zoning Act that says you can only reasonably regulate again as to those uses. And what that means is that for each particular use, if a regulation of the town, if the use cannot comply,
Just height, and you wanted to have a large steeple. in between.
exactly, yep, Mormon church.
Okay.
Right. The issue, it doesn't stop there. Then the board is required, or the town is required, to go to the next step. That step is to look at what is being requested, look at what is the purpose of the bylaw requirement that they want to go beyond, and look at what the impact will be on the use, and to balance those two things. And if the impact on the use is greater than the benefit to the town, then it has to be allowed, even though in black and white it says no. So that's because this is a special protected use now. It gets the benefit of that consideration, and that's what the board is being asked to do tonight.
So our decision basically is the driveway allowed to go in a roadway, a new creation of a driveway?
Correct.
I mean, to look at it, it's clearly the ideal place. But are we obligated to provide a garage in this ADU that is not, the 836 square feet is the ADU, but the 294 square feet is a garage?
Right.
And it must be separate, not physically separate, but that would end up being 1,100 square feet, which would make it oversized if you call it part of the ADU.
Right. Correct. And under the state's definition, the garages do not count for counting
The
900
ADU
square
size
feet.
is not.
Right,
So
correct.
we're really deciding whether we grant the garage or the access to the garage as well.
Correct.
Okay.
Right.
I mean, it's something to discuss, it's something to understand.
Correct.
If the
Right.
garage was of a size that was under the 850, is it, the
900 square feet.
900, if it was under that, then it'd be a much different scenario.
If the ADU was greater than 900 square feet, that's a completely different scenario. Those, it
But
has to be
that
the size.
exceeds a dimensional requirement.
Right, that would then take it beyond the state protection, but we do have an ADU here that would be protected, is protected because it meets that definition of 900 square feet. So
But
the
is
garage
the-
is not
Garage
counted.
is not counted in the
Not
900
counted.
square feet.
So it's not part of the ADU?
Correct. Well, it can serve it, and that's allowable, but it's not
Yep,
counted
yep.
as part of the 900 square feet.
Right, this is tricky.
Yes, it is, agreeable.
Are there any thoughts from the board at this time?
Well, mine at first, it seems like the ADU is part of the front yard. But maybe I'm looking at it incorrectly. That must be the side yard.
Is it allowed to exceed the footprint of the house as to the front?
It must comply with the dimensional requirements, but according to the plan, it does comply with all dimensional requirements.
So Jose, if I wanted to build a freestanding garage, I cannot put that in front of my house, is that correct? As part of the bylaw?
Per the definition of the bylaw, that is correct, yes.
Because that's another consideration is this proud of the house proper?
This one specifically?
Yes, this one
Yeah, no,
specifically.
this one meets the requirement. It's not in front of the house. It is,
So that it's to
Okay.
the side, but it's allowed to
it
be
meets the
in front of
front,
it
the
on the
front,
side.
right, the front
That's
yard
acceptable.
setbacks,
Okay.
yes.
I'm sorry, I think I
Well,
interrupted, I was just trying to figure
I
it
have
out.
an idea. I drive by this house almost every day, and it really is, it's a massive lot. And I think people should go look at it, just because it's the first one, and we wanna make this correct. We wanna make everyone.
You feel a
uneven.
sidewalk, or we could
We don't-
individually go
We really
by?
don't even need a sidewalk, just drive down the road.
Right, so we don't need to meet,
No, I don't think so. Do we need to meet anyone there and see where, cause we
Sorry?
can figure
What
where, if we drive by and look at your lot,
Yeah.
we'll know where the,
Yeah, no, I'm
ADU
right
is
next to
going.
Stacy, by the way, so
pardon me?
I'm at the end of a dead end, so
Yeah.
there's no sidewalk
Yeah,
there.
right by my niece's house.
Yeah, yeah.
Right. So I think that would help us a little to look at the lot.
okay.
That's only my opinion, of course, and whatever you think.
Oh, go ahead, I'm sorry.
I have a question for town council. Did the state, in enacting the ADU bylaws per se, from their standpoint, did they say one way or the other that curb cuts are allowed or not allowed?
The
Did they
sta-
say anything about it specifically?
State regulations don't address curb cuts, they don't address driveways, not expressly.
All right, so the town,
If I may, while the regulations do not specifically address it, the model ADU bylaw put out by the state does actually address it. And town council is aware of this, and they basically, as I put in my application, say that, for a corner lot, a curb cut may make sense, and it has to be reasonable. So, just again, the model ADU bylaw from the state does specifically address this, because there was commentary during the regulation period. And when the state put out the model ADU bylaw, they specifically said that's about curb cuts.
Yeah, just to be clear, so the state model bylaw is not a regulation, it's not a requirement. It's state guidance. It's the state's proffered guidance to towns about how to apply the regulations. They then address this particular situation and say, it might be reasonable in certain circumstances, particularly as a corner lot, to allow for a separate driveway or allow for a separate curb cut, notwithstanding what your regulations might say. That's all it says. It doesn't say yes or no.
so the state is saying reasonableness is really the law
And that's
here.
where the Dover judgment comes in.
Sorry?
That's where he's referencing the Dover judgment, so that we have the reasonable ability to make. that.
Right, and the town, when these rules came out, the planning board did what they could to, in some ways, cut back on what was
Limited in its
loopholes in what
scope.
the state had put forward. One of them was coming forward with this requirement that there could not be curb cuts. When obviously there are circumstances where curb cuts are the most reasonable thing you could do, and not onerous. In the state, but one of the things the state wanted to do was not have something onerous on someone who wants to have an ADU. They made ADUs a right, and they didn't want to put anything that was onerous on anyone having an ADU. In this case, having the driveway not in the most logical place is onerous on the applicant. And that was the intent of the state, not having anything onerous on an applicant because they are trying to increase the stock of low-income housing. That's basically where it all came from. So it would seem to make sense that in terms of reasonableness, the town, the planning board, when they put together their impediment for no curb cuts, they didn't leave in any dialogue about reasonableness. They just said no, period. Which really should have gone back to it would seem it should have gone back to the state, and the state would have said, all right, these are Chelmsford's changes that they want to make to ours. And from what I think council believes, they never came forward and say, yeah, Chelmsford's changes or requirements are all acceptable, except for this one, which is not reasonable. That never happened, correct? So but the state continued to leave it nebulous.
If I may, sir, I would like to.
Can you
one
hold on a minute?
clarification.
I'm trying to hear him. Just hold up.
Sorry.
Go ahead.
So reasonableness is where it resides. The state was almost locked down the rules for ADUs, except for this curb cut issue, which left it to boards like ours to say, is it reasonable or not reasonable? Whether the the town decided that curb cuts were allowed or weren't allowed, it would still be on us to say it's reasonable or not reasonable. In this case, it seems to be perfectly reasonable and not to be onerous on the applicant. I don't think there's any neighbor who's going to complain about this curb cut in this particular location. There may be cases where the additional curb cut could be onerous on the neighborhood, but this certainly doesn't seem to be one of them.
Good point. Could we see the neighborhood shot of the, if you wouldn't mind, of the lot?
I'd like to chime in, sir.
Yeah, I just wanted to clarify again. I appreciate your remarks that the state did have a chance to review the ADU bylaw, including the curb cuts, and town council made representation to the state and the AG that the specific bylaw lines would in fact be applied on a case-by-case, fact-by-fact basis. So there was a review by the state on this, and town council did make representation in writing to the state, and the state's letter back to the town did incorporate that as well. So
And the case by case
Is that
is here.
correct?
Like, when the commissioner denies, the case by case is, that's what we're here for.
Is that the case? Did the state come back and say it's on a case-by-case basis to the town?
So, just to be clear about that, the bylaw, when it's adopted by town meeting, is submitted to the Attorney General for review and approval. The Attorney General is looking to see if the bylaw conflicts with state law. The Attorney General found, in this instance, with this particular piece, that it does comply with state law. However, Mr. Ferrani submitted a letter to the Attorney General as part of that review, suggesting that this was an unreasonable regulation. We were asked as town council to respond to that letter. We then sent a letter also to the AG. Mr. Ferrani is correct that in that letter we acknowledged, we didn't promise, we acknowledged that state law requires the board to do exactly what it's doing now, which is make a reasonableness determination if a case is brought to the board saying, in this instance, it's not reasonable to apply this bylaw to this application.
So,
Just to add to that,
so the state is saying that in this particular case, in this particular part of things, reasonableness is something that the ZBA can rule on.
And absolutely, yes. And in fact, the state gives you a test in its regulations that you can apply to determine what is and what is not reasonable. And the first part of the test is you look at the intent, the purpose of the zoning bylaw that's being looked at. In this case, that's the driveway requirement. What is the purpose of having a requirement that there should be no second driveway?
What was the town's response to that?
No, I'm saying this is what's in front of the board now. This was not part of the review with the Attorney General. This is how the test works when it's applied to an application.
So this board is gonna determine what's not acceptable and what is acceptable, period.
What's the purpose of the bylaw? And then looking at this application, what is the impact on this person?
Were you saying that this board is supposed to be over the planning board's rule, that we can say, yeah, it's a legitimate requirement, or it's not a legitimate requirement?
So the requirement's legitimate. The requirement itself is legitimate. On a case-by-case basis, this board has the authority to determine that in a particular situation, it's not reasonable to apply it.
And on a case-by-case basis refers to every one of these that comes before us.
Only if the building inspector denies it based on a
Well, he's gonna
violation.
deny every one of them
He has to.
because it's against town law.
this is why in my opening comments I said, based upon the ZBA getting a number of these, or a dozen of these, the planning board may go back into the bylaw and recommend revising it accordingly, if there's a common trend with the zoning board. But I think the initial statements that you made, and then what Jamie was referring to, looking at the neighborhood, now you're beginning to do a fact-based analysis. So I think you're on the right methodology here. You've indicated that, maybe members want to do a drive-by, since it's the first one. But while it's not a variance or not a special permit, many of the same attributes and criteria that you would normally consider would likely be part of this fact-based analysis.
I think in step one of the test, right, what's the intent of the bylaw according to planning board and town meeting, right? Not to have two driveways next to each other in the front yard, right?
Well, there was never any discussion of what their intent was.
I think,
They just made the rule.
okay, I think we could probably all agree they don't want two driveways in the front yard. I mean, that seems pretty common sense, in my opinion. But if we look at his property and his proposed location, it really kind of veers to the side. He's on a corner lot at the end of the road, looking at where he is, from the position of where he plans to build said ADU. Putting the driveway where it wants to be, I don't think would visually look like two driveways parallel to each other in the front yard, in my opinion. So I don't think, looking at it from here and here, it would violate, in my assumption, the intent of the no cut, no curb, preventing, because if he was the lot next to him and they tried to do it, it would look like two driveways parallel to each other in the front yard. And I don't think that's what the planning board or the town really wants to see, as opposed to his lot, and it's more to the side, he's on the side, in my opinion. It's just my assessment. But you're right, we can't speak
I
to
agree
the
with
board.
you. I think the ultimate intent here is that we don't want to set a precedent one way or the other, that they are acceptable or they're not acceptable. We're
Well, any
looking at it from the
decision we make
standpoint of,
doesn't really
in
set a
this
precedent,
case
'cause it's-
only,
yeah. But
Yeah,
it-
we're
It is
not held to
acceptable.
precedent, but
Yeah.
it's very powerful, regardless if we're held to it. It's, he did it, why can't I? And it's very
Because
powerful.
that's why we analyze every case individually and based on its facts presented, so to make sure we can articulate our decision based on the record set in front of us.
well, I think that
try and
any motion would have to include dialogue of why
Of course.
we found this one acceptable, because we would be using it as a defense, basically, later on if we had to.
Right.
the end of the day, we're voting on a driveway, right?
Yes. Well, I mean,
He can
it's,
put his ADU there one way or the other, the ADU can go, we're voting on a driveway,
but,
right?
I mean, the bigger picture is preservation of the neighborhood, characteristic of the community, upholding the bylaws as it was voted by the town, right? So town members voted on it, went to town meeting, like there was this whole governmental process that the community went through. That's what we're supposed to represent. But we have one of our community members standing in front of us where that, as a blanket, may not be completely 100% beneficial in his particular situation. So, yeah, it is a driveway at its singular look, but in the grand scheme.
I'm not trying to belittle the driveway,
yeah.
I'm just saying that there's the ADU, which is the structure, which
Right,
is allowed
right
by
to build.
right,
Yep.
which will go in one way or the other, even if we say no, if he wants to not put a driveway, he can still put that structure in.
Yep.
So we're not exercising any ability to deny him his ADU, that's,
No.
Right, it
They'll
would-
just park,
it would
they'll
be a
just
matter
park
of-
in his driveway and have to do a long walk.
Or you
Snowy
install a
walk in
driveway
January.
Yep,
across the,
to
that
the,
travels
to the,
there. I mean, you can come in and put a driveway in along the front of the house and get to the garage. It's
cut
not-
away all of his nice
Not
lawn.
impossible. I think I really would like to look at it as well with Charlie. I think that we would continue this and get a look at it in person to understand it. Is it staked at all, sir? The property itself, is it staked for the location of this?
I actually did call DigSafe, and
Yeah, they probably wouldn't be doing, well, so to have DigSafe, you have to mark it on the property?
yeah, and basically there's no gas lines or whatever, except
But did you stake out the price so we could go by and see where you'd like to put this?
The
I have not,
driveway.
because I have not been requested to do that, and I would request the board to rule expeditiously, given that I filed the permit request months ago, and there is a limited building season. I'm sure you can see reasonably that, again, it's on a corner lot, there's a dead end there. Mr. Forst is familiar with the area. Again, I literally have no neighbors on the side as I put in my property, in my application. I have no neighbors, there's no sidewalk. I understand that if a house in front of a school, where it's a busy street, wanted to have a second driveway, that would not be reasonable. This is the literal opposite effect of, where a driveway, if there's a driveway to be permitted at all, mine pretty much falls right towards, there's no, interference here. So I would request the board to please rule now so I can get started. A drive-by is not gonna help. I'm happy to pull up Google Maps on my phone to show it to you, but I mean, literally, there's no neighbors there. There's the Votes farm, where at one end, and that's it.
Mr. Chair, just one
Yes, sir.
comment. For all of these, not just this application, one of the factors that you consider in terms of impact of this bylaw on is the cost to the applicant of having to comply. And that's actual cost, that's dollar cost. That's one thing the board can and should consider. If that cost is outsized compared to the benefit to the town, then the result should be that an exemption is allowed.
when you say benefit to the town, just the benefit of
Gaining
not,
the ADU.
The benefit of applying the bylaw in this particular situation.
so keeping it from having that second driveway.
Correct.
Okay.
Part of the state's ADU dialogue was that city and towns, if they wanted to modify it in any way, they shouldn't be doing anything that's onerous to the applicant, money-wise. If he misses the building season and he has to build it next year, the cost of building is gonna be more than it is now. It's gonna have a direct cost detriment to
I
him.
can't make a decision on that. I don't find that
But
reasonable at all.
I'm just saying, that's part of why the state did what they did, that they said you can't cause the applicant to spend more money by putting some impediment in his way, based on their rules.
They signed off on it. The Attorney General said, this is acceptable. Our bylaws are acceptable.
No, he said that in some cases you could do it, and in some cases you can't do it, based on reasonableness. They didn't say you can't,
On this specific item of a driveway, a second driveway, that was a ruling?
that
Or
it
just
was the
generally?
ruling, from what council said, they came back and said that the board, the zoning board, has the ability to use reasonableness, and reasonableness can be many things.
I agreed.
And cost is one of the reasonableness items you might want to throw on there. And they said reasonableness is in the eyes of the board. If the board says that it is reasonable, in this case, specific case, they can find against the hard rule that the town has, because they've given the board, the ZBA, the ability to be reasonable in the interpretation of the town's rule. They left it up to the ZBA to determine how hard and fast that rule is. Is that paraphrasing
That's
it
essentially
correctly?
correct, yes.
So we have the ability to say, in this case, it is reasonable, and the town's idea of why they wanted to do this, have this rule, doesn't apply in this case. In other cases, it may apply, but we are the final authority on that reasonableness.
I don't see how a drive-by is gonna confirm or change anybody's mind on what they're gonna do with this. I think the applicant has a reasonable request that we act on this.
And I mean, I think this Google map here does a pretty, I mean, it's wide open and pretty cleared lot. Allows
Can
us
you go back to the house I'm sorry.
No, yeah,
Can you go back to the house itself?
the other lot.
So if I have it right, this is your
Yes, sir.
this being shown there? Okay.
Again, literally,
the
there's half
driveway
an
is-
acre.
And the driveway's gonna be
all
way
the
down
way
there.
around, right?
Yeah,
The driveway is right at the other end, it's the dead end.
Yeah, it's effectively, I mean, I think
It'll be
you
out
pointed
past
it
that
out.
bush.
There's a fire hydrant at the end, my property goes all the way there. It's literally half an acre of nothing, which they mow.
You see the hydrant right there.
Yeah.
How far from the hydrant is the new proposed driveway?
I think it's a little farther towards the street from what he has up now in those arrows.
I don't think it's shown on this.
Is the hydrant
Plan that, I'm sorry, I don't have the
Oh, there's the
measurement
tree
exactly,
line,
but-
so it's a little bit past the tree line, okay, so it's like the bush and the tree line, in between the bush and the tree line.
I mean, there are some neighborhoods where we have driveways closer to each other.
Yeah, on lots,
Absolutely.
yeah. Probably the next two by next street, the next two lots, I think we're closer.
I guess one of my struggles here is simply, the garage is not the ADU. I mean,
But that was explained by council.
Well, I understand it's perfectly legal to do this, but we're being asked to approve a driveway to a garage that's not part of the ADU.
Right.
The law doesn't say everybody gets a garage with an ADU. It says you get 900 square feet for a dwelling, and he has an 1,100 square foot dwelling, adding a garage.
I thought the garage
so-
didn't count as the dwelling.
And if I may, I believe that state law says that the 900 is livable area, not
Oh, no, I
counting the
understand
garage.
that.
So,
And we're required to approve the living area. We're not required to approve the garage. Nothing says we have to approve a garage.
But there's no, there's nothing in anything
Oh,
that
no,
says
that's what
you
I'm trying to
can't have a
understand.
garage with an ADU.
I don't think the garage is in front of you.
Yeah, we're here
garage
for the
is not
driveway.
there.
The old,
I think the way I look at it is applicants have a choice to make, particularly for detached. Do they want a garage or do they not want a garage as part of the ADU
So
application?
if he chose to make a 5-car garage there, right up to the setbacks, that'd be fine.
No, I don't believe the building commissioner would
Be the
deem,
trigger there then.
any detached structure that's not an ADU over 900 square feet requires a special permit. I think you could also make a reasonable interpretation that a 900 square feet ADU is reasonable to have no more than a 2-car garage.
I'm not saying the garage is not reasonable. I'm just trying to understand
Right,
where,
no, but to speak to your point, I think applicants, as the ADU law is set up, applicants have a choice. And in this case, the applicant's choosing to include a garage, as I understand it, to serve the ADU. They have that right.
Created a structure that is over 900 square feet.
The state law the state law does not include the garage towards the 900 square feet.
So then why can't he have 5 garages?
I think then we'd say it's not reasonable.
I think the commissioner would likely say that's not reasonable, and that's not within reasonableness of a 900 square foot
Or just
ADU.
Reasonableness
But
is
but
the
this
decision.
but this application is what is it, a one car?
One-car garage,
one-car
and by the way,
garage.
even if I didn't have a garage, to access that ADU, because it's detached on the side, the most reasonable way is still from the street. It's not across my front yard, so the garage is a moot point.
I disagree with you. I think that if you didn't have the garage, then they could park in your driveway, and there could be a walk to the house. Well, that may not be your decision, but it certainly would be in keeping with the town's request.
And that would not be
You're allowed to
reasonable,
disagree,
again,
it's
given
fine.
the location. And again, this is about approving the driveway only.
It's really
be
about
able-
approving the curb cut, and which is to be what the planning board is having a problem with, and did make a ruling on, not gonna have 2. It wasn't vague.
Now, again, what is vague about it is again, the state has said, and the town council has committed, that this is to be applied with a standard of reasonableness on a case-by-case, fact-by-fact basis. And if my location isn't reasonable for a driveway, nothing is. And because it's on the side, and because of the location, because it's a dead end, because of those sidewalks,
Brian, applicants in this particular case, a detached, could still want a driveway without a garage.
I
So
don't
it's,
disagree.
so the
and
garage
that can
isn't,
be
I don't
accomplished
view the
without
garage
a
as really
curb cut.
being in front of the,
It's gonna be a problem down the road to approve another curb cut, because the next guy in here is gonna say the same thing. And he has a point,
I think,
you know?
yeah, I mean, I think you need to
It's-
continue going through the methodology.
I
on
just
the-
What about
see a
any
problem.
abutters that
If
get
I may,
notified on
This whole
this?
thing hinges on the reasonable test. The next guy coming in asks for a curb cut, and we say, well, you're too close to the existing driveway. It's not reasonable. I think this one's reasonable. I think the applicant's correct.
and so, if I may, the state model ADU bylaw specifically states that the ZEO, the zoning enforcement officer, who is the building commissioner in this case, shall, again, as part of the model ADU bylaw guidance, shall waive town bylaws that are unreasonable in that particular case.
But he didn't.
Again, I'm thinking because the model ADU bylaw came out after the town had already passed its bylaw, the town bylaw did not give the ZEO the power to conduct that reasonable test. That test now falls on the ZBA.
Procedurally, that was all discussed as part of the planning board deliberations. The planning board understood what they were proposing, and town meeting was presented and understood what they adopted. It was understood that there was no clear guidance or directive to empower the building commissioner. And by default, everyone understood that meant that people had the right to petition the zoning board.
Let me say, I'm a town meeting member. I was there when this was voted. There was no great discussion about this specific part of it because it was just kind of swept up with the rest of the dialogue. It was left to us to make a decision. If this particular case is determined as not acceptable, I agree with the applicant. What the heck could possibly be acceptable? It's in the middle of nowhere, basically, and is the most logical thing to not make anything onerous on the applicant. You know, we still reserve the right to judge every one of these individually. This is the first. You know, maybe it would have been better if the first one was not acceptable, and we could argue that part of it. But this seems to be totally acceptable where he wants to put it. and not owners, and you got nothing back from the neighbors that they found this unacceptable, I would assume?
We haven't had public comment yet, but,
We did not receive anything in writing,
Okay.
no.
Are we going
This is a
to,
public hearing, and all the abutters were within 300-foot radius were notified, and it is a public hearing, so at some point.
We can open it up and see.
are we
what-
going to have
We'll
a
go forward in
public
Oh, yeah.
comment?
we
Oh,
can
but we
certainly
do get
have this
departmental
vote
letters.
now. I don't have a problem with
don't
that.
know if
I
we
just
wanna-
don't agree with it.
Should we, is there anyone here who's want to speak
I
on
think-
this?
To get to that, we haven't gotten there
Yeah.
yet.
And we can go there right now. We have
Do you
letters,
wanna
right?
do the departmental letters first?
Okay, I'm gonna read in the letters from the town regarding this. 28 El Dorado Road, that is not us, right?
Yes.
Okay. The officer reviewed the project application plans, and the DPW has no concerns regarding the location of the proposed driveway.
And they keep
I can read them all. Trash and recycling services are made through primary dwelling and remain capped at that limit. Trash and recycling will not be provided at the new driveway. The proposed ADU will be near or possibly over the existing sewer service. The applicant must contact the DPW Sewer Division to coordinate any necessary actions to alter the sewer service. Sewer capacity impact fee to be assessed with a building permit per sewer use regulations 6. Bedroom calculations, section 14.5, $15 per gallon of daily wastewater flow will be applied for adding bedrooms, per Title V. One bedroom is equal to 110 gallons per day. Sewer connection as proposed for the ADU must connect on property. A plan showing the proposed sewer connection must be submitted to the DPW for review prior to the building permit approval. Plan should include the proposed elevation at the ADU and proposed at the tie-in location. A licensed contractor must apply for a sewer and trench permit and the DPW at the start of work. Erosion control must retain sediment on site. The street should be swept and cleaned from construction dust. Silt sack or other equal erosion control should be installed in catch basins at the front of 28 El Dorado Road. Consideration should be made to install roof drain dry wells to reduce the volume of stormwater runoff generated by the roof of the proposed ADU. This is not a requirement for approval. That's the letter from the engineering. Fire Prevention Office, Administrative Appeal, 28 El Dorado Road. Dear members of the board, Fire Prevention Office has reviewed the administrative appeal for 28 El Dorado Road and offers the following comments. An application shall be filed with the town's E911 committee for addressing purposes. Clear and visible numbering must be posted on both structures located on the property. All construction shall comply with the current requirements of the Massachusetts State Building Code regarding smoke, heat, and carbon monoxide detection. Plans will be reviewed by this office as part of the building permitting process. A final inspection by the Fire Prevention Office shall be required prior to the occupancy and use. We respect this request the letter be made part of the public record and incorporated into your final approval process. Josh Abbott, Captain, Fire Prevention Office. We have a letter from the Chelmsford Water District
No concerns.
with no concerns. We have a letter from the Chelmsford Water District, no concerns.
Duplicate, sorry.
We have a letter from the Chelmsford Police Department with no concerns. We have a letter from the Treasurer Collector with no concerns. We have a letter from the Board of Health with no concerns. This time, if there's not further questions, I'll open this up to the audience for concerns, comment, opposition. Seeing none? If we have enough, we can motion to close the public hearing.
Brian, why don't we not close it till we do the next thing on the request? It's the applicant also requires that all the legal fees, notifications, and filing be waived. That's part of the request.
Right. I don't know.
So I think we
what
should
are
do
thoughts
that
on that?
before we
Well, we should
close the
definitely take
public
that up, yeah. Does anyone have any thoughts on it? Why do you want to do that?
I'm sorry?
Why do you feel you have the right to have all the fees waived?
Because, I'll tell you why.
Thank you.
Because the town, when passing the bylaw, did not give the zoning enforcement officer the ability to conduct a reasonableness test with regard to the Dover Amendment use. So therefore, for a applicant to request that, there should not be additional fees, because the town bylaw does not match the bylaw and does not match other towns, which allow a reasonableness test request without additional fees being paid, if that makes sense.
I understand what you're saying. I mean, aren't we following the due process that we laid out?
Can I ask what additional fees were incurred by having to be here today for you, as opposed to what additional fees were incurred as opposed with him denying and you appearing here as opposed to him doing the reasonable test and approving?
There was a administrative appeal fee, I believe.
I can speak to that.
Thank you.
The application fee for an administrative appeal is $300. There were 15 abutters on the certified abutters list, which equaled $52.50 for the
Okay.
mailing fee. And then the newspaper legal ad was a total of $678.26. The three added come to a total of $1,030.76.
Okay. Thank you.
I,
You're welcome.
I think the intent by the state was that if we cause him unusual costs unnecessarily, then he shouldn't have to pay those. For example, if he had to come here tonight, hire an attorney to come here tonight to defend this situation, that you could potentially make an argument that that is a burden on him that he shouldn't have had to. But as it's written up there, these are normal costs and have no bearing on causing a burden that would be the same thing for anybody to
If
pay.
anybody wants to appeal the
Yeah,
decision
they have
as
to
the
pay
law
these.
was written, this would be the process.
Right,
And
and
even though
that last part shouldn't apply to this case.
And in my opinion, every town has their right, as a planning board and as the town meeting, to make their bylaws what they fit for the community. And why we have a zoning board of appeals is for the town members to come to us if they don't like the commissioner's decision. So not if the town doesn't want that right to, discretionary right to approve, override the zoning laws, then that's why the town members come to a zoning board of appeals. That's why the town has elected us to serve here. So, unfortunately, I mean, that's how the board and the town wants to maintain that level of procedural process. I mean, that's unfortunately.
that process.
Yeah.
What I'm saying is that you can follow the process, but that the town of Chelmsford has imposed a special cost on doing that process, as opposed to allowing for the state's model ADU bylaw, allowing the zoning enforcement officer to make that reasonable determination first, and then, if needed, come to the ZBA for an appeal. Because the town bylaw itself was so rigid, it starts off not allowing the CEO to even conduct that reasonable decision.
I'd like to see if every town who's adopted a new bylaw has given the authority to the commissioner besides Chelmsford.
Regardless, it's what our town
It's
It
what
right.
we,
voted
It
on.
right.
but this
So
is
it's-
I don't
our
think
It's a moot
It is
point.
ours. It is moot.
Yeah.
I mean, we
and
have-
maybe the
that's
law
how we
needs
want
to
it.
change,
What
but
it
at this
is.
point, it's
And
done
everybody who comes to
correctly.
the zoning board of appeals for any appeal, it's the same amount of
Special
fees.
permanent variance.
Right.
Special permit
The
variance,
average is
so.
I had to pay them.
That is the price you pay for building in Chelmsford, I guess.
To the town council, did
Yeah.
I hear you correctly earlier that after these have come to the ZBA enough times, then we will have set a precedent for the building inspector to make a reasonableness decision?
So your decisions, if you make several decisions, it will provide guidance to the building commissioner from which he then could make that decision on his own. He's not prohibited from making that decision, but he chose in this instance, I think rightfully so, says the bylaw is black and white. You don't comply. I don't feel qualified to make a reasonableness determination at this time. You can appeal it to the ZBA. They can apply the test.
So playing the tape forward several months, and we've heard, say, a half a dozen of these. We've made a decision, this is not reasonable, this is reasonable, and so on and so forth. We didn't necessarily, we may not put in dimensions, like you can't have a driveway 10 feet away from another driveway, that kind of thing. But after a certain amount of time, the building inspector or commissioner will have the, if I say, make the reasonable test on his own.
I think the town's tendency is to throw it back as a warrant back to the town for an amendment to the zoning laws. Is that?
Yeah, well, that's where I'm going.
Yeah.
With this. So
Right.
in the future, the fees that the gentleman incurred won't even be there because it will be approved by the inspector.
That would be true. If he doesn't have to appeal, then there wouldn't be any fee. But of course, the
But
fees are for costs of the town. That's what fees are, and those costs have been expended in this instance, so it's completely fair.
I'm gonna play devil's advocate as well, because everybody who exceeded an ADU over 750 square feet had to come and get a special permit or an appeal, and now by right, it's at 900 square feet, so should we waive all those people who?
No, what I'm saying is, that, yeah, I know what you're saying. But no, what I'm saying is, someone who comes to us, say, a year from now, the fees won't be incurred, perhaps,
I know,
because the
But-
building inspector simply approved it with a reasonable test.
but they're here now.
I mean, we can ask Jose, but I don't think he has it doesn't, if we did 100 of these, it still doesn't give him any guidance unless we specifically say, which we can't, be 10 feet away from another driveway. The curve of the, you can't put it where there's an extreme curve.
Well, there's no guidance on the dimensions or the position of the driveway.
Well, we
Again,
wouldn't
it's a
even
reasonableness
create those.
test.
The town would have to do that at town meeting and become part of the zoning law. Am I off on that, Jose? Would you feel?
I think this is a learning curve for all of us right now, but I think
Absolutely.
I will do the same thing I did on this one for others, which is under Article 1. Second driveways are prohibited per the advice of KP Law and my conversation with the planning department. It is best if I proceed the same way I'm proceeding
And
tonight.
if it ends up in the zoning law that this is what a second driveway can contain, then you would be very comfortable granting or not granting, but until that
Then that will be
happens,
something that I could do by right.
I mean, we can't set the guidance for that, I don't think. I don't know
Well,
how that
that's
would
why
function.
I started with town council. I mean, I thought I heard.
Is that accurate to say we can't really set guidelines for that as far as, wouldn't we be changing the zoning laws by saying you can have a second driveway as long as you, whatever the parameters might be?
No, your reasoning on each decision might, from that, people could say, okay,
But to have the
here's a rule.
decision, they would have to come to us.
Exactly,
We
it
would
does-
have to have the legal notice
Right.
and the newspaper ad, which is significant.
Yeah, you
It's-
can't
it's
amend the
real
zoning
money.
bylaw by your decisions, right?
Right.
Kinda like
We
he's saying
can't
is-
not make the decision without the legal notice or
Right,
without the
correct.
newspaper
The same when
ad.
they amended the bylaw a couple of years ago after we saw all of the same special permit for the 10% increase, right? We saw like 100 of the same things, so then they amended that it did require.
And at that point, the law changed.
The law changed,
Yeah.
because they saw a trend
Yep.
and was like, okay, here's
And
the trend.
that's only done, if I'm not
Through
mistaken, at
town.
town meeting.
Yep.
Right.
We can't just.
So the
But
fee's
until that
something that
happens-
we've ever ruled on?
No,
No.
no.
we've never-
Why is it
It's
even
the
brought to this
business.
board? I mean,
That's
that's
just-
more
that's
about
a-
the town
that's-
itself. Yeah.
That's just,
Just, Mr. Chair, technically, it's a request that he's made. It's not part of his appeal. It's been made in his appeal, but it's really just a request to the board.
So
with
we
the
don't have to
motion, we
vote
would-
on that separately.
I think the
Separate
motion would
motion.
either
It is a
include
separate
or
motion?
Yeah,
exclude,
I'd include that.
because it's written, is that
Okay.
correct?
Yeah,
In the
I think
motion?
you could just, yeah, you could have a separate motion and just say,
Separate motion.
with respect to your request to waive the fee, denied.
Yeah, okay. Any further questions?
Make a motion to close the public hearing.
I like that.
No second.
Yeah.
Second by Peter. All in favor?
Aye.
Opposed? Seeing none, it's unanimous.
Laura, Brian, Stephen, Jamie, Charlie, and Peter.
Peter.
The 5 regular members.
Okay, could I make a motion?
Absolutely.
Because this is the first one, and I'd like to make a motion to approve the first ever, right by denial per Article 1D4 for parking for the first ADU. In the motion, if I could, the filing fee, the abutter notifications, and legal fees, shall not be waived.
So you're making a
I'm
motion to
making two.
uphold.
Uphold.
Uphold
the-
or overturn?
No, keep the fees the same.
Are you just talking
For
about?
the, for the driveway.
Oh, the driveway is
It's
definitely
administrative
approved.
appeal.
We always make a motion in the affirmative.
We approve the right of
So,
denial.
Yeah.
I guess that's the backwards.
I don't know what I'm agreeing with or not, that's why I'm
It's an
asking for
administrative
clarification.
appeal.
Administrative
Yeah,
appeal.
could you do those
So I should
separately? It would-
reword that
Yeah.
differently.
All right,
please.
we'll have
Or do
two
separately.
motions.
You know, two motions.
to approve the administrative appeal, is that what
Okay.
the motion was?
Yes.
Thereby overturning the building
This
Yeah,
is-
commissioner's
overturning
decision?
the by right
Okay.
denial. Okay.
So the single
Two
motion now is
motions.
just for the
Two
driveway.
motions.
Yes.
And if you vote yes, it's to approve the overturn the building inspector's decision. A no vote or opposed would be to uphold the building inspector's decision.
Right, kind of backwards,
Yes, it is.
but it's okay.
We're
Yeah, we need to
approving
make
his
it in the
application.
in the affirmative.
So we're,
So
Approving
you
his
wanna-
application, which is to overturn Jose's decision.
Is everyone clear on the decision?
No.
Can I'd like to make a motion to overturn the building commissioner's, decision
Okay.
on 28 Eldorado Road for the administrative appeal,
And allow
and allow the
driveway.
installation of the driveway.
Okay, that's much
Correct.
better.
Okay, that'll be the motion that is made.
That's the motion.
To allow the.
So-
Would you like a second? or s-
Second.
Second by Charlie. All in favor?
Second by Charlie.
Aye.
Nice and
Opposed?
hold on. So, okay, hold
3 to
on.
2, is it a supermajority?
Yes.
So it is denied.
Could I just see that was Stephen, Peter, and Brian opposed?
Opposed to it.
Okay.
And then we would have a second vote, correct, for the fees?
Make a motion to deny the waiving of the fees for the application for 28 Eldorado Road.
You're voting to,
Make a motion to
Oh, sorry,
approve the request.
I make a motion to approve the request to overturn
Waive the
or waive
fees.
the fees for the filing
Not good.
for 28 Eldorado Road for their administrative appeal.
I second the motion.
second motion. So that means that if you vote in the affirmative, you're approving overturning the
Approving
fees.
waiving the fees.
Okay. All those in favor? Seeing none, opposed? Seeing 5.
Okay.
Wait, Brian, just so I'm clear here, we did not allow the driveway to go in?
Correct.
Correct. The vote.
why? What is, I don't understand. What is the reasonable logic? Do you have to provide a reasonableness logic?
I don't agree with you, so that's why I voted to not do that. I don't know the opinions of the other board members.
I
That's
don't
why I
think
have
this
a
is
board.
the area to discuss any of that, right? We voted and, I mean, at this point.
There'll be a written decision that you'll have to issue. Once it's drafted, the
Right.
board will have an opportunity to vote on that, which would provide reasons for the decision.
And there's an appeals route for that as well?
I'm sorry, what?
There's an appeals route for that as well. If you're aggrieved by our decision, you can appeal it.
I don't understand. Why did the other members not vote?
We're associate members.
I'm sorry?
We're associate members.
Only five people vote.
5 people
Five
vote.
people on the board.
Okay. But I don't.
You can, maybe Evan can explain it better. You can appeal this
Yeah,
decision.
The applicant understands his options. I think he's just in shock and maybe a little puzzled as to why 2 members who voted against may not have articulated. But as council mentioned, the decision will have to provide clear reasoning.
Yeah, he's saying 2 out of the 3 did not articulate. Brian
Oh, okay.
was very vocal about his
Oh, okay.
reasoning.
I
got you.
I feel what I feel.
One of the options to you is, if you do appeal this, and there's a process to do that, part of that process allows you to claim unreasonableness causing you harm and ask for the monies back. If you have to hire a lawyer, you could ask for the money, if a higher authority agrees with you.
So what exactly was the vote?
3 to 2 against.
Against
again-
approving?
3 to 2 to uphold the building commissioner's assessment that the town of Chelmsford bylaws do apply. The reasonable test was upheld with his decision and the application of the rules of the law.
And the reasonableness, reasons were what exactly?
Well, the next steps
You're gonna
are,
get a decision.
staff
We're
was
not
gonna
gonna
draft a
elaborate at this
decision.
point.
We're gonna ask the 3 members who voted against to provide their reasoning based upon the testimony this evening. Council will review it, we'll clock it in with the town clerk, and there'll be a 20-day appeal period. But the decision, as council said, will articulate the reason for denial.
They're gonna put it in writing for you, and you'll get a copy.
Is there a
Yeah.
way to rapidly appeal this?
You have to have a written decision filed with the town clerk before an appeal period begins to run. So the board
has
has
to be
as
within
much
20
time. Right. The board will draft a written decision. Once it's filed with the town clerk, you can appeal.
Mr. Chairman, just for the record, that in the meantime, the applicant can continue with the,
ADU build.
with the construction project.
I believe that would be correct,
Yeah.
yeah.
You can continue, you can build the ADU. This won't help, you just can't build your driveway.
No, but
The
again,
decision will be clocked in within 14 days, is what we normally
But
do.
if you go back, no, I'm sorry, but the town has to provide me a reasonable alternative to a driveway. I mean, again, it literally.
The alternative to the driveway, which I don't believe the town is required to provide for you, because again, it is not part of the ADU, it is part of the garage, but you can put a driveway from your driveway right in there.
Again, it literally
Again.
makes no difference if there's a garage there or not. Because of the location of the ADU,
When they give you the written decision, you'll have your reasoning by those members that voted against your application, and you have a right to appeal. But their decision about the driveway does not prevent you from building the ADU. So it won't stop you from incurring or cause you to incur any costs or delay in building the ADU. So
that's completely not true, because without a,
So we voted, it's not gonna change, so. Sorry, it didn't go the way you'd like it to go, but
But we do need to move on to the next application, unfortunately.
I'm sorry?
We do need to move on to the next application.
and we're gonna take it out of order at this point. We're gonna hold off on Old Westford Road and take on 180 Mill Road. The applicant is Tim Scally of Constructioneer Design and Build, representing America's Americo and Erica Luongo, requesting a variance under the zoning bylaw 195-9, conformity to construct a new family room and a home office addition to their conforming single-family dwelling, which does not meet the minimum 25-foot setback and any other relief deemed necessary. This property is located in the residential RB district. Good evening.
How you doing?
Did you want the family in the room with you?
I mean, yeah, maybe I'll call him in real quick.
Just to give, they had stepped out because the truck was just gonna call the owners.
Do we have to finish Morose first?
Thank you guys for your time tonight.
Okay,
I think that's just a signature.
okay.
We were just waiting on the names.
All right, I want to make
Oh,
sure.
I'll use that, I'll put that right here.
Jonathan, thank you.
Yes, thank you, Mr. Chair.
Thank you.
All right, sir, thank you. Earned your money, that's for sure.
It ain't over till the flat lane's over. We're doing Mill Road, right?
Yep.
180 mil.
180 Mill Road. Good
180
evening.
Mill Road. Thank you guys for your time tonight. I want to say a special thanks to Becky and Jose for all their help behind the scenes with the homeowners and putting everything together. It's kind of been a journey, but basically, I met the Luongos back in about November when I was working on a project at State Street. They approached me to do an addition. They were going to do a lavish addition originally, but then they decided to scale back because they've had a third child since, and they can't really, pay for it at this point. So right now, they scaled back the project. We were attempting to do a 21 by 16 foot addition on the west side of the property. New windows, new roof, just kind of jazz the place up for now. As you can tell, it's kind of a pie-shaped lot, so it's tough. We don't really have the required setbacks that we need to meet the town's 25 feet. So basically, we're here today for variance to hope to get your approval to help this out. And basically, both AJ and Erica work remotely from home. And right now, the third bedroom they're using as an office, which we're going to be moving down into the actual basement space. There'll be a living room upstairs, and that'll be accessed from the dining room, and then the office, the new office, will be accessed from the basement itself right now. So basically, we're just asking to see if you guys would give us the variance on the left-hand side.
Sorry. Don't worry about the buffer, it's conservation, we don't care about that. We don't have to worry.
Okay.
He is outside of the, he's
Easy.
outside of the 50,
Okay.
but that's conservation, we don't have to deal with that.
Yeah, we've had north out already to mark out the locations that are marked out on the plan itself. Would it get better dimensionally if you move that addition forward? So we've played around with that with the surveyor bunch. We tried to move it forward in front of the fireplace, but there's actually the gas meter is right there to the left of the actual fireplace. And then also we tried shrinking it down, and it just doesn't fit the look that they're going for, It is only a one-story, would be cathedral living room, so it's going to be tastefully done to match the rest of the house, obviously.
I mean, to get to 1'10" farther back, it would be pretty far forward. I'm not really against moving the gas line to accomplish that, but the chimney is functioning at this point?
Yes, sir.
Couldn't the gas meter just be moved?
It could be, yeah, definitely. I was just trying to save cost,
But
Do they understand the
if it
implications
moves
of a variance?
forward, there's no variance needed.
Yeah.
Doesn't seem to be.
But there is a chimney there and the gas line. The gas line is just
But
a
the
cost.
chimney, lots of people have chimneys in their room.
And also, there's, in the rear, there's a double window, right over here, so they can view the whole backyard, where there's like a patio out there and stuff where the kids play and stuff. So that's kind of why they wanted that to kick out in the rear there. I think it's like, I want to say 8 feet, the bump out. So
The three-prong test for variance doesn't unfortunately include design features of the project.
But it does include lot shape.
It does, yes.
And it does include topography, which is also the wetland.
So you do have lot shape because the lot shape creates that diagonal in the setback.
the wetland, moving it forward would actually get him further away from that 50-foot buffer.
I'm sure you guys spent a bit of time trying to figure out how to make it comply.
Yeah, we really
It's-
have. We've
It's
done-
mildly, you have a 1'10", and I think you would get the special permit.
Yes, yeah, the 20% off,
Correct,
if it was a
off of
special permit.
25.
But we were still off by 2 square feet at that triangle, at that 20-foot mark. So we're still kind of not going to comply with it where it sits right now. So that's why we're kind of asking for the variance instead of the special permit, you know?
Less than 2 feet forward. Is that black dot where where the gas meter is?
Yes.
Yes, yep, right there, yep. I'm sorry, no, it's actually on the left-hand side, the meter.
On the left-hand side of the chimney?
Yeah, yep.
Yeah, that's where the black dot is, right there.
No, that's not it, though.
That's the
Oh,
right-hand
it's
side.
behind the
It's
chimney.
actually right here, yep. So
Okay.
right there. So it's about 18 inches off of that chimney itself. So it's kind of a tough spot, you know?
If the room were moved forward to the chimney, what does it mean for the distance from the corner to the property line? Do you know?
It wouldn't get you there.
It still wouldn't get that 21 by 16. It would have shrunk down. I think we did the math, it was like 19 or 18 and some change to make it just hit that 20-foot mark for a special permit.
But if it moved all the way forward, it would.
Yes, and it just aesthetically wouldn't be what they were looking for, because that was my thing too, is like, let's move it forward, but then the chimney, the 2-foot by 4-foot chimney, that's 8 square feet, is already taken out of kind of a small family room as is, you know? We went every way possible, AJ and Erica, and they had their hearts set on this, so this is why we kind of presented to you guys to give us some guidance or variance.
And what room is it connecting to in the main house?
So there is a dining room there now, so there's a kitchen, dining room, and then there'll be a basically a 5-foot cased opening going into the new addition.
It's really not a large family room now, it's a tight space. It's not tiny, but,
I think that's exactly how my great room is.
Yeah, I mean, with the vaulted ceilings, it'll make it
Huge
feel
room.
bigger at least,
to
you know?
shrink it would be, we have a variance phobia here. It's pretty strong.
Yeah, I know.
It sticks with the deed. I mean, it travels and you sell.
I think we do have a good argument that the lot is an odd shape.
It's
It
a
has
large lot, it's
topographical
.92,
issues.
it's a big lot, I mean, I don't know if you have a site map, but I mean, it's nice, all wooded, it's pretty set off from the neighbors, and AJ and Erica also went around to all the touching abutting neighbors and got a letter of consent, more or less, showed them the drawings, what was gonna happen, and they all signed it and said that, they would love the improvement, and they enjoy the Luongos, obviously.
And having the great room directly off the back of the dining room as opposed to the left
Put you into the
of the
wetland.
dining room.
There's a bulkhead there too.
Yeah, there's a bulkhead in the rear. I mean, I think they do down the road have intentions on maybe they hit the lottery, they can do this that they want to do down the road. But so they want to leave their options open, kind of leave the family room to the left with the office below. Opens up the bedroom upstairs for the kids.
Was there consideration for a land swap with the neighbor? Had that been approached?
No, it hasn't.
So it's really not as onerous as you might think, but you can approach your neighbor, and if they're willing, you sell them 200 feet, and they sell you 200 feet, and there's a jog in the property line. It's very legal, very easy to do. It's a,
Better get the
legal
surveyor together and.
I might suggest you consider that. I don't know the flavor of the whole board, but it is really a struggle to pass a variance. And it has to be a supermajority. It was 4-1, so
Yep.
it's a challenge. I might suggest you look into that, and I know time is of the essence, but we would meet again October 2nd. And if you can talk to the neighbor and understand if it made sense, it may be some of the neighbors, you know, he's not losing any actual space, he's just giving up
And it looks like it's
the area, it'd be a bit of a Z, it would go out far enough to give you, and really, you're talking, you know, 10 inches, 1 foot 10 inches.
Yeah.
Would get you the special permit, so it's not a big step, but it might be something that's a lot easier than being denied, honestly, because if you are denied, then you're gonna go back and do something anyways.
Solid, yeah. And I mean, I wish it was built six and a half years prior, because then it would have met the 1961 setback, 17 feet, would have been no problem, but like, obviously that
right.
doesn't apply. But, yeah, we're just hoping that you guys would, let us move this along, since we've been at this since, January, you know?
I think it is an odd lot shape. Is there any thoughts from the board as to whether this is acceptable, or do you think the avenue of trying to do a land swap with the neighbor is practical? It's certainly legal to do, you just, you know, have a surveyor draw it up.
Are there any abutters that are saying anything about it?
My understanding is the butters were
No, I
in
actually have a
favor of
letter,
it.
if you want me to read, do you have time, I mean, kind of, do you want me to read out the letter that they signed, or?
It's probably in the packet, right?
No.
Oh, no.
I did not receive written
Okay.
letters of support, so if you wanna submit that to the board, you need it.
The
Yeah.
most influential letter would be from the abutter right next door.
Right.
Yeah,
on
that
that
would
property line.
be,
The rest
number
Patricia
three.
and
really
James
don't really
Sherman?
mean
Frank
anything.
Vitale, 181.
Tally. Do you have Hagel, do you have Sherman or?
Oh,
Sherman?
176, yeah.
176.
Yeah, we have Hagel, Sherman, Vitale, and Puja. All signed it, basically saying that they support the addition at 180 Mill Road. They understand the variance is required due to a minor setback. As direct neighbors, they have no concerns about this project. The planned addition is well-designed and will be a great enhancement to the property, which will be positively contribute to the overall value of the street. I believe this variance is reasonable and should be approved. Thank you for your consideration, and they've all signed it. The four
already-
closest
Yeah, I
abutters.
would think the land swap is the most reasonable solution.
It's already
It seems that the applicant wants to put it where they want to put it because it makes the most sense to them, period.
And it's frankly, to my thinking, not oversized for the room. It isn't like this is gonna be.
Right.
you know,
Right,
it's a-
and they
it's a-
don't need a lot of room on that
Right, not
side
a
from the
terrible
neighbor.
side. Yeah, yeah.
You know, it's not unheard of. People do it all the time.
Well, I think there's, it really would be less than probably 20 square feet of land swap. I mean, I know how bad it can set you back, especially this time of year.
Well, just the attorney and all that jazz, and
Yeah, yeah.
registry of deeds and surveying, and we could be talking another $4,000, you know?
Yeah.
In my viewpoint, I think it makes sense, and if it was a special permit, I'm all over it, all day, every day.
Yep.
But the variance part of it is,
You do have the topography and the lot shape as an argument. I do, you know,
what's the topography? Like,
the wetlands.
oh, well, yeah, the wetlands are stopping them from putting it further back, not,
Further forward.
yeah, further forward.
It does, it's an impediment.
Or put it behind.
If they go farther back, they'll be further into the 50-foot wetland. It looks like
Right.
they're at the edge of the 50-foot.
I don't think anyone's asking them to put it further back, because that would just make it
Well, that
worse
was
overall.
what was discussed as an option.
I think the option was
behind.
further forward.
Or
Further forward in order to avoid the boundary.
If it went to the chimney, I don't believe you'd accomplish it. If it went to the front of the home, I think you could accomplish that. It would be very close. Again, it's 1 foot 10 inches, it's not. With options, including the land swap, I guess I would request that you come back with, and if you said they will not do a land swap, and we can't move it forward, or if the math is done, did you do the math and see if it was even with the front of the house?
It did, it just aesthetically wasn't what they wanted at all.
But it did get you into special permit.
It did, yes, it did. It was
And
right at that
I
edge.
understand
Right at
you
the
want
edge.
what you want, I appreciate that, the variance is very difficult to accomplish.
Couldn't it be built not perfectly square, but in a different design to move that corner only away from consideration?
Sounds good, make it look really funny.
I think that would be
You want
problematic,
a
but
turret?
nothing's impossible.
Well, there's lots of houses that have a small family room, and then there's a garage, and one is set this way and one is pushed back this way. It's, they're all over town.
Yeah, yeah. Well, what's in front of us does not,
Cutting the back corner off the house and making it,
just make it not have a back corner, right?
That doesn't make any sense.
seems
I mean,
worse than moving it to the front half. So,
I think there's a bit of a split board here. I think you can ask that we vote on it and go back to the drawing board if it is not effective. I think that would be an option for you.
Yeah, I mean, obviously we'd like a positive, outcome, but I mean, maybe take the vote and see where it goes and, otherwise we're gonna have to go back to the drafting board,
Okay. Let me
Before you
do
do,
the
you have to
letters.
read the departmental letters and public input.
Yep, I was gonna figure that.
Thank you.
Gonna read the letters. 180 Mill Road is the Conservation Commission, and this project will require notice of intent filing with the Conservation Commission. Which you can move ahead on. From the Chelmsford Fire Department, special permit application, 180 Mill Road is technically a variance. Dear members of the board, the Fire Prevention Officer reviewed the special permit application for 180 Mill Road and offers the following comments. Submitted architectural plans indicate compliance with current code requirements for detector types and locations. Smoke, heat, and carbon monoxide detectors shall meet all applicable provisions of the Massachusetts State Building Code, including interconnection and power source requirements. As part of the building permit process, all plans must be reviewed and approved by this office to ensure full compliance. A final inspection by the Fire Prevention Office will be required prior to occupancy. We respectfully request that this letter be made part of the public record and incorporated into your approval process. Josh Abbott, Captain, Chelmsford Fire Prevention Office. From the Board of Appeals, from the Engineering Department, Sheila Joyce. This officer reviewed the project application. Number one, record sewer does not show any conflict with the proposed structure. Two, erosion control devices must retain the sediment on site. These must be installed prior to any work or earth disturbance. It should be noted that the property is located within the wetland and wetland buffer zone, and the Conservation Commission should be coordinated as necessary. Consideration should be made to install roof drain dry wells to the proposed addition to keep the stormwater runoff within the property. This is not a requirement for approval. We have no concerns regarding 180 Mill Road from the Chelmsford Water District. There are no concerns for 180 Mill Road from the Police Department. There are no concerns regarding 180 Mill Road from the Treasurer or Tax Collector. And there are no concerns regarding 180 Mill Road from the Board of Health. This time, unless there are further questions regarding the letters, I'm going to open it up to public comment, either in favor or opposition.
Brian, could, the homeowner,
Able to
Erica, say a
just
few
say
words?
Certainly, certainly.
So Erica Luongo, I'm the owner of 180 Mill. The reason we came here to apply for that variance is because that lot size, our lot size, is oddly shaped. As you can see, we have a very large crew, and we really need the space. We're really growing out of our home. And I think because our lot is oddly shaped, we do qualify for that variance. We've worked with Tim extensively trying to move it, adjust it, bring it in, and it's already a tight space as is, what we're trying to add on. So I think the way we have it is aesthetically, it fits what a lot of homes have. I think if we do move it forward, aesthetically, it's not gonna look as nice as we would hope. I don't think it lines up with the house at the front of the house as well if we were to move it, so it kind of will jut out, which feels a little funny. And so, you know, we both work from home. We have a large family now. I just ask that you take all of those reasons into consideration when making a decision. So, thank you.
So it is a single story.
Correct.
The addition.
Any further questions? And I get a motion to close the public hearing by Peter. Second by Stephen. All in favor?
Aye.
Opposed? Being none. And I would like to make an emotion.
Making a motion, Pete.
I'll make a motion to approve the variance under zoning bylaw 195-9, conformity to construct a new building at 180 Mill Road, which does not meet the 25-foot setback and any other relief deemed necessary, with regard to the letters that were read into the meeting.
A second?
Second by Jamie. All in favor?
Aye.
4?
2, 3, 4.
Opposed?
4
Passes.
Thank you. Thank you guys so much.
Rare day when a variance gets through.
Have a good night. Thank you.
Very
guys.
rare.
Thanks for your time.
You said it.
Enjoy. Have a good night.
Have a good night.
Yeah, tell them good luck.
Good luck with it.
There you go.
Oh, yeah, you can?
Yeah,
You avoided. Okay, we're gonna backtrack a little to off Old Westford Road. Also known as the Triangle Lot at Old Westford Road, Davis Road, Graniteville Road. The applicant, George Allen and Son Construction, is requesting a variance under the zoning bylaw, section 195-9, conformity to reduce the 80% minimum upland lot area requirement to subdivide the land and create 2 buildable lots and any other relief deemed necessary. The property is located in the residential RB district.
Chairman, I'm going to recuse myself from this one.
Jamie will recuse, and that will make Glenn.
Glenn, yep.
Okay. Good
Thank
evening.
you. Yeah, Mr. Chair, good evening. Attorney Jim Dangora with Shea Dangora Nelson and Billerica. I represent the applicant, George Allen and Son Construction. I have Son with me, T.J. Allen of George Allen and Son Construction. What's before you is a variance, a petition, but what we have is 4 acres. It is the triangle lot that some of you folks are familiar with. If I may approach, Mr. Chair.
Yeah.
Becky, could we go back to the plan that's been approved by the planning board?
Yes.
Okay, so it's 4 acres. We presently are approved for the 2 building lots, so we're not asking for additional building lots from you people. What we're really looking to do is just to straighten this lot line out, so we can get rid of this jog here and create some uniformity within this 4 acre triangle. We spent considerable time with Evan and Jose before we submitted this plan to the planning board, which was endorsed. This plan here meets all of the zoning requirements, including the depth requirement, meaning one of your criteria is that the lot has to be 150 feet deep. So what we've determined is that the frontage for Lot A, which is this area here, would be on Davis Road. That would require access to the frontage. It would require a driveway off of Davis Road, which would mean more impervious surface within the buffer zone. So what, and as a matter of, so what we're struggling with is this, just to eliminate additional impervious in the buffer zone and to create 2 nice more uniform lots for these potential buyers of the house. So we have upland in this area here, in this area here, and that's the area where the two houses will be developed. But this scenario here creates some issues. This house here, this owner here may take some liberties with this gentleman's property here, and it could create, adverse possession issues and other issues between neighbors. But it would also require more impervious within the buffer zone. So this complies. We need, it's a 40,000 square foot zoning district. We need 32,000 square feet of upland. Here we have 35,000 square feet of contiguous upland. Here we have the 32,025 square feet of contiguous upland. So this complies. Becky, if we could then pop to the plan that's before the board. So under this scenario, which is the proposal that's before you folks,
This is the request for
is to cut the 4 acres this way. It would, we wouldn't meet the contiguous upland on Lot B, but we would certainly meet it on Lot A. So thus, the variance. The other thing that this plan would do would obviate the need to bring the driveway in off of Davis Road and pave within that buffer zone. So, one of the purposes of zoning is to create some uniformity. And what's very interesting is if we comply with your zoning bylaws, we get a little bit of a two peculiar lots. But if we go the variance route, we have more uniformity with respect to the two lots. So what's driving this is the reduction or eliminating additional impervious within the buffer zone. We consider it a soil condition issue. The access to both lots here under this scenario would be off of Old Westford Road. Both homes would be connected to municipal sewer as well. So under either scenario, we don't need septic systems. We're going to connect to municipal sewer. So it's the soil conditions that's driving it, and the desire to avoid additional impervious surface within the buffer zone, which would require us to go back to the Conservation Commission. So that's the application in a nutshell, folks. It creates more uniformity. We do have two lots that conform. We're not asking for anything more. All we want to do is just straighten out that lot line and again, create some uniformity. And that's all I have, Mr. Chair.
So in Lot A, you have 40,312 contiguous upland?
No, you need...
That's what you're asking for?
Yes, that is correct. So we need 32,000 square feet, right, to conform. We have 40,812 square feet here, and on Lot B, we're at 26,000, so it's about 5,400 square feet under the requirement.
And I'm going to ask the obvious, can that line be adjusted to diagonally go across? Does that affect your frontage, or what is stopping you from equaling it?
Yeah, it's been engineered over and over, and this is what our engineer told us that he could do. So, and the other issue is,
What would be the problem
I
with
think the
adjusting that
access.
line?
There's
TJ.
the stormwater pits for the house are on the side. We had to test for those, being far away from the wetlands with the house positioning.
That stops you from going up and then left and then up
And then
again.
the setback from the street.
That's where I was thinking, Steve. I don't know. So this comes down to point, and then this space here, if this was 5,500, would give you your upland there, reducing this, but you can reduce that, you don't have any problem with that, that's, 40,812. It's something like 5,600 feet. And I believe it's been engineered, I don't think you'd
Oh,
be
yeah.
here if it wasn't, I just don't understand the obvious thing staring at me, that's all. And it's
That's
50
whole-
by 100,
The whole
right?
field on the backside by the schools. that's
50
all.
by 100 would be 5,000?
The access for this lot's gonna be through this area here, I don't know. if
On
that's
Old
in
Westford
there.
Road, yeah?
Yeah, for some reason, the engineer has told us
You-
this
you
is the
know,
plan that
I mean,
works.
I'm just looking at it obviously very quickly, and I'm not an
Yeah.
engineer.
Yeah.
But I don't know why that line couldn't be adjusted to accommodate, it's not a frontage issue.
No, it complies with everything, except for that,
Brian,
contiguous
what are
upland.
you referring to?
To move that
I just don't want to see the downside of it. To take this line from A point and come over here, which would take the contiguous and put it in lot B, you just came down here. And again, you need to get 5,000 feet, it's 50 by 100, it's not a massive area.
Do you have the plan, do you have the Concom plan, or the
Yeah,
plan with the houses on it?
Yeah, that's the one right there with the stone wall.
I'm sure you looked at it, I'm not trying to make a problem, I just don't
I'll get
understand.
you there. So here is the Concom plan, and that's where the houses are situated.
Situated off the wetlands here.
We're trying to honor the,
Your idea is to continue through this directly,
Yes. Yeah.
and this house cannot travel this way, because it's not shown
No,
on the other
because
plan.
it's to the wetlands.
And if you come across here, you wouldn't be able to gain 5,500. Okay. I knew it had to be fairly.
yeah, yeah, we're pinned in here because of the
Setbacks there.
Is that an elevation map? Is that what that?
Yeah, it
Yeah,
has
this one.
elevations as well.
Would you like to see it?
Yeah, if I could, please.
That's the Concom plan.
This is the
But does it have the elevations on it?
And I knew as much, you know. Right, and their opinion is they cannot, and the location of the houses on that make it much clearer that that would be a setback issue. Pretty much the house is gonna go where the existing barn is.
We have to honor the 50-foot wetland, so
Right.
the houses go in a particular area. So to move the lot line back and forth.
And you
Messes
guys are not
with-
the first to try to get lots out of this place, it's gone on. for-
They're essentially locked, the location of the houses
Yeah.
are essentially locked in. The
Right.
commission doesn't look at lot lines
Yeah.
when they locate the houses, they're looking at setback from wetlands. So the location of the Concom-approved house lots on the planning board approved lot plan
The envelope is tight.
is essentially locked in.
Yeah,
The
yeah,
location of
pretty
the houses.
Good.
So that,
To get the 50, to get the 25, to get the wetland setback.
Right, right, right.
Look, the issue is that the lot on the right side, based on what was pictured on the screen, is too small, correct?
No,
contiguous
no.
upland is too small.
The contiguous is under the 32,000 square feet.
It has adequate lot area.
Yeah, we have, it's 94,000 square feet. It's a 2.1 acre lot.
He does get the vineyard, though,
Pardon me?
the vineyard.
The vineyard?
You're back in now.
I haven't been over
Bring
there,
that
no.
story up.
And this barn's coming down.
Yeah, the barn is basically where the house is gonna go, it looks.
Yeah. Yeah. So we're strapped with, honoring the 50-foot and here, in this area here and this area here, so.
Pretty wet, huh?
Yeah, it's a really interesting piece of property.
Yeah, yeah.
It's a lot of land, and it is interesting that you can only get 2 lots out of it, but that's perfectly fine. We're not looking for any more than,
Hey, 30 years, people have been trying to build on that thing
is that right?
forever.
Yeah.
Sonny Alves owned that, is he still on it? Is he still alive?
Mr. Avila, yeah, he's
Yeah.
still alive.
Yeah.
Yeah, and Yeah, he's been patient through this process, been to the planning board, been to the Conservation Commission, we're en route to, Board of Health and Stormwater Management, so we're pretty far down the road. We do appreciate the time that Jose and Evan have spent with us on this. But again, it's a matter of creating some uniformity and creating any issues that jagged property line would.
Even resale would be tough, yeah.
Yeah. Well, it's 2 lots now, and it will be 2 lots after.
I just have one question.
Yeah.
You had mentioned do you have to go back before conservation?
If this wasn't approved, we would then have to get conservation to approve that driveway that went across the frontier, which would add considerable impervious to within the buffer zone, so.
Well, there's certainly pervious driveways as well, so.
Yeah, and there are, but it still would require an additional filing. That plan that you just looked at here has been approved, with the driveways coming off of Old Westford Road, so.
Conservation approved that.
That is correct, yeah. And I think they weighed in on some of the, actually, they had a no comment, I guess, in their comments. I was kind of hoping there'd be a little more, but I'll take a no comment
Take a no,
from a
yeah.
Conservation Commission, you know.
Right.
I guess I will read the letters in and we'll move ahead here. From the Board of Health, Donna Greenwood, Public Health Director. Dear Planning Board, I'm going to read this in as well. This letter regarding the proposed project Triangle Lot at Old Westford Road, Davis Road, and Graniteville Road. The lot is proposed to be divided into Lot A and Lot B. This proposed project, specifically Lot B, has a property line in the Town Water Resources High Aquifer Protection Zone 2 and the State Water Resource Protection Zone 2 wellhead protection area. Therefore, this project will require approval from the Board of Health pursuant to the Town of Chelmsford General Provisions, Chapter 201, Board of Health, Article 7, Groundwater Protection Zone for the following property. Upon approval from the Board of Health regarding the Town of Chelmsford General Provisions, Chapter 201, the Board of Health, Article 7, Groundwater Protection Zone, if this party is not able to connect to the town sewer system, it would then require an on-site, on-septic system that must meet Title V regulations pursuant to 310 CMR 15. Septic systems, along with completing the Health Department's disposal system, construction permit application, and inspection process. Respectfully, Donna Greenwood, Public Health Director. But you have met that, and you will not be putting in septic.
Or we are putting in sewer, and we will address that wellhead protection district issue with the Board of Health. If you want an illustration as to where that wellhead protection area is on this plan, it's not in the area we're developing. It's actually, it's off the corner of Lot B in this area here. I know it's tough to see.
I got it located on this one too.
Yeah, that's all right. So we'll straighten out what we need to straighten out with Board of Health.
Chelmsford Fire Department, Fire Prevention Office. Special permit request, Triangle Lot at Old Westford Road, Davis Road, and Graniteville Road. Dear members of the board, regarding the above referenced special permit request, the Fire Prevention Office provides the following comments and conditions. The applicant shall file an E911 application through the town's E911 committee for the proposed building lots. Any construction on lots shall comply with all applicable codes, including but not limited to the Massachusetts State Building Code, 780 CMR, Massachusetts Fire Prevention Regulations, 527 CMR, NFPA standards, and the Town of Chelmsford bylaws. The plans will be subject to review by this office as part of the building permitting process. Based on these conditions, this office does not oppose the proposed plan. I respectfully request this letter be incorporated into the board's approval process and entered into the public record. Sincerely, Josh Abbott, Captain, Fire Prevention Office. This is from the Sheila Joyce, Project Engineer, Zoning Board of Appeals. Off Old Westford Road, AKA the Triangle Lot at Old Westford Road, Davis Road, and Graniteville Road, applicant George Allen and Son Construction. 1, erosion control devices must retain the sediment on site. These must be installed prior to any work or earth disturbance. It should be noted that the property is located within the aquifer and the wetland buffer zone, and the Conservation Commission order of conditions shall be coordinated as necessary. Consideration should be made to install roof drywall drains to keep the stormwater runoff within the property. This is not a requirement for approval. We have a letter from the Conservation Commission regarding off Old Westford Road with no concerns. We have a letter from the Chelmsford Water District regarding off Old Westford Road with no concerns. We have a letter from the Police Department for off Old Westford Road with no concerns. And we have no concerns regarding off Old Westford Road from the Treasurer Collector. That is the extent of my letters. This time, we're gonna open it up to the community. If anyone would like to speak in favor or opposition to this application, now is the time. Seeing none, entertain a motion to close the public hearing.
I'll make a motion to close the public hearing.
By Peter, second
Second.
by Charlie. All in favor?
Aye.
It's unanimous. Is everyone clear on the subject, that it's the upland contiguous land, meaning it's all attached? There is other upland land on the property, but it is not attached to this one space.
Seems the most feasible way to divide that lot and make it clean for the
I
homes
mean,
to be
it's
put on.
certainly much cleaner for
Right.
the future homeowner, for
Future
the
homeowners.
problems of adverse possession. And I
Right.
think it's really more housekeeping for them than changing anything.
Right.
It just makes a cleaner setup, which I think is a good idea.
I think it keeps the driveway away from the wetlands also.
Right,
So
the
that's a
driveway
big
thing,
thing.
right.
Right.
That's a,
Which is
that's a good
topography.
point, Charlie.
Yeah. So I'd like to make a motion to approve the variance for the triangle lot, because of the 80% conformity in the upland dry land, in consideration with all the letters being read into our meeting.
I'll second that.
Second by Peter. All in favor?
Aye.
Unanimous.
Very
That
good.
never happens.
Thank you. Thank you very much, folks.
Good
Have a
luck.
good night.
Yes.
Jesus. You sure you're not a
All that,
comedian?
you didn't even hear you.
Oh my God, that
Too
was
funny.
perfect.
He's good.
Okay, moving right along. So we have Old
That was
Westford Road,
good.
we have 180 Mill Road.
150 north?
150 North Road, owner Viking Development LLC is requesting a variance under the zoning bylaw, section 19531, for a monument sign that does not meet the minimum 15-foot front setback from the street line and 20 feet from the side lot line. Wall signs that exceed size and other relief deemed necessary. This property is located in the residential RB district. You guys are the daycare, is that fair to say?
Yep.
Okay, just to get
Preschool.
acclimated.
Preschool. Okay, that's it.
Good evening. If I can have your
Hi.
name, address?
Sure. My name is Heather Dudko, 27 Old Meeting House Road in Auburn, Mass. And I'm a sign permit consultant for National Sign Corporation, who is the sign installer for the school. And we also have a representative, the vice president of real estate for the school, here in attendance as well for any questions.
What happened?
His face looked familiar.
Oh, you know him.
Oh.
You better recuse yourself.
No, no, no.
Been in front of you guys before.
Yeah.
For the previous, that's why, that's how I remember his face. I don't know him, just remember his face from the previous.
So as you know, this is a new school in town on North Street, and we are here to present the proposal for their signage that they're looking to install. It is in a residential zone, therefore the signage does not conform to the regulations in the residential zone. So I'd just like to walk you through the entire sign proposal, and then we can address any questions for that.
It's not gonna wait down your nose, is it?
Okay. First, there's a chart, a little chart there that has a summary of all the signs. So we are proposing a monument sign, 27.5 square foot, 2 wall signs, illuminated channel letters, and then 5 non-illuminated logos on the building. So that's the entire scope of the signage. The next slide will show the monument sign. That is proposed as an illuminated sign. The background will not illuminate. The logo and the letters push through, and that will be the only portion of the sign that will illuminate. Down in the packet later, I'll show you, we have an example of how it illuminates. I did provide a large site plan. We do believe that the sign will meet the 15-foot setback from the street and the 20-foot setback from the side. It'll be 1.7 foot from the lot line, but we do believe it meets the 15-foot setback from the street. The next slides will show the proposed channel letter set on the front elevation. 12-inch illuminated channel letters on the north elevation, 30.3 square foot. And that's the main entry. Is that correct, Chris? And then you'll see on each left side and right side are where the non-illuminated logos are proposed. The next slide should show the additional wall sign, illuminated. The 2 wall signs are the same. No, they're not, I'm sorry. This wall sign on the east elevation is 22.7 square foot. It's a little smaller than what's on the front.
This is the one facing the 495 ramp?
On this elevation, Chris?
This faces what we have, North Road. This is what you would see passing by.
So what was the previous one then?
It's our front entrance, which faces north, so
It faces,
it faces the parking lot.
okay. So that's the one facing 495 ramp?
Correct.
Okay.
And this also has the 2 logos on the left and the right side. And there's an additional.
This that we're seeing there is the North Road
Street view.
view.
The street view.
Okay.
No, the north. This is the east.
This is what faces, this is our North Road elevation.
That's what I thought, okay.
And then the next slide shows just the additional logo. On the south elevation, there's just one additional, but that shows the 3 complete elevations. And
those are not illuminated?
correct. And then I can show Becky, if you wouldn't mind showing the rendering that we sent with the illumination. That's how the signs will illuminate.
Do we have an illume count or LED number? How bright are these things?
We do see that there's the conditions for the illumination, and we'll adhere to those. I don't have the specs on these drawings, but we will adhere to the lumens and the nits that are outlined in the illumination statute.
Are we planning on having these on at night when you're closed?
Yes, and I believe there are time frames where they must be off within your code, which we would obviously adhere to. We do like to have them on for some period of time following closing for marketing and branding purposes and have people passing by. But like the site lighting and everything else, we can put it on a timer and have them turn on.
I have a question. Their petition says it does not meet the minimum 15-foot setback. But she began a discussion by saying it does meet.
15 feet from the street.
From the street.
Not plot.
But there's a sidewalk there. Is that what creates the difference?
So the confusion and the clarification there is the language says street line. So I believe we are 15 feet from the curb, from the street line, but we are only 1 point something feet from the property line.
Right.
So if the board feels the language is from the right of way, then we're looking for a variance from that. If the language is supported that 15 feet from the street line is how it's written and how it's meant to be, we comply. It said street line instead of right of way, which.
So basically,
I
is it
assume
a
it's
50-foot
gonna be
roadway?
up in the air.
Is that what it would be, a 50-foot road?
The right of way, the width, I don't know the width of
Yeah.
So this being in a residential district is a big part of this problem, is that correct, Jose?
That's the sign.
And there's a picture of it.
It is the reason why they're here, Mr. Chairman.
Because the zoning is different in the residential area.
Yes, sir.
Yet they are certainly allowed to be in a residential area, as we
Yes, sir. So
did-
we
did quite a ways
we
back.
use historical data with a school on the same road to grant this, to issue the letter so that they
The
could be.
Montessori school, there was, yeah.
It's Primrose. Primrose isn't limited, is it?
What?
Is Primrose? They have like, but it's right. It's not like
Yeah, I know.
glaring
It'd be up in the
backlight
air.
like this one.
Based on the topography.
I'm sorry.
The Primrose one, it's not.
the road is right-
They got
yeah,
little
yeah.
like spotlight kind of.
I don't recall.
I thought you were saying
Thank you.
No, 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 no.
The fine turn.
If I
Yes,
could.
the technical term.
Typically, external illumination has worse light trespass than the LED backlit because it's actually blocked in some fashion.
Okay. I just feel like it has less illumination.
The sign is gonna be kind of up in the air based on the roadway, is that, when you drive through there, it seems the whole project is up.
Yeah, there's an elevation change of, I think, 10 or 12 feet up to the building, plus the building being 12 feet tall.
Will people who drive by there be able to see the sign?
They should
Will
have.
it be up on a,
Yeah, so the building sign, on the east elevation facing North Road, they should be able to see the Gardner School lighting there. The one over our main entrance, that's more of a branding, just a school main entrance, you know.
Not gonna see much of that unless you're in the parking
How
lot.
high over the street level is the monument sign?
The monument sign, I think, is like 6 feet in total height with the base and all included.
Right, but I mean,
Oh,
your
that's.
property goes up, I mean.
It's
It might
at
be a couple
sideway.
feet. That's pretty much at street grade.
So 6 or 7 feet or something would be the maximum height of the monument.
Correct.
No one
From the
driving
road.
by is gonna miss this.
Hopefully not. That would be our approach.
Bet you're.
You have to be blind. They shouldn't be driving if they do.
So you think due to the incline, it will just add a couple, like 2 feet?
Yeah, if that.
If that.
If it's pretty close to the road, so we can't be that far off.
It's gotta
in
be
terms
pretty
of-
much
Right,
like that. There
right.
could be a small incline, but
Yeah.
yeah.
You took a lot of dirt out of that property. I mean, you lowered it quite a bit.
Yeah, there was an attempt to balance earthwork as much as we could. But, through the whole planning process and everything that we went through, there was give and take on what was needed, so I think there was some effort.
Were there conditions with signage? I don't remember seeing them.
I don't think that we
That wasn't in front of us.
delved into that
And has there been
whatsoever.
any
The
written
building wasn't
at this
part of our
point?
front, it
Has
wasn't
there-
right in front of us.
Right.
Signs wasn't included? Yeah, because that wasn't, their plan wasn't in front of us.
Mm.
Any further questions at the time? I can read the letters if there are. Nope, that's not correct. Sorry.
Which one? 31, okay.
We have a letter regarding 150 North Road with no concerns from engineering. We have a letter for 150 North Road with no concerns on fire prevention. We have a letter from Chelmsford Water District with no concerns for 150 North Road. We have a note from the police department regarding 150 North Road with no concerns. We have no concerns from the treasurer collector for 150 North Road. And we have a letter with no concerns from the Board of Health, which makes sense. I'm going to open it up to the community. If anyone would like to speak in favor or opposition to the signage, now is the time. Please approach the podium. Seeing none, I'll still be curious as to what all these people are doing here.
You have 3 more cases, don't you?
We haven't got the intermission yet.
I know, there's a lot of papers here. Who took that month off? All
Yeah.
right, could I get a motion to close the public hearing if there are not further questions?
I'll make the motion to close the public hearing.
I second the motion.
Second by Jamie. All in favor?
Aye.
Opposed? None. So they need to light it. They'll be complying with the hours that it's lit. It doesn't seem to be over the top for,
I just wonder, because doesn't most businesses are allowed just one sign on, if it's in a business district on the building?
no, there's a square footage calculation for that.
It all depends. I mean, you can have multiple sign. In this situation, they have a freestanding sign, and they have,
I mean, but attached to the building, isn't it one attached
they have to
sign?
comply with the 20% requirement on the facade.
That's the square footage.
Right, I thought it was 15.
Two elevations here.
Yes.
What's the criteria for a variance on a sign?
So their true problem is that they're in a residential district, so there is no, you can't put the sign on your house. So where
They
they're
can't
in the
be lit.
residential district, they still have the rights given, but the same as the ADU, where the state has said that you can put churches, childcare, now ADUs in residential districts, and that's where they don't comply because there's no signage rule for residences.
Yeah, is there a-
Well, there's there are
criteria
signs,
for a
there's sign rules for residents.
What was that, Steve?
Residential districts, we have
Is there a-
signs for residential districts.
Is there a criteria for a sign variance that has to be met somehow,
The application doesn't fit very nicely with the traditional variance that you deal with.
Yeah.
But normally, that's the zoning relief that's required. The bylaw doesn't have a special permit provision. So I understand you're struggling with applying the traditional.
Are there any pathways for, like, if you got more than 12 trees in front of your house, you get a
I mean,
sign?
you could attempt to take all that into consideration, if you wanted to view the landscape plan, we already talked about elevation. The applicant indicated why they wanted the proposed signage that they're asking for. So you could attempt to apply the traditional 3 variance criteria. You may find out in attempting to do that it still doesn't really have a relevant application. The other thing I will say is, and the applicant hasn't said this yet, it is a Dover use. The only reason we sent this to the zoning board is that was exactly the way the Primrose School was handled. So we were just being consistent. If attorneys were involved on either side, because it's a Dover use, there would likely be some talk about not applying a variance standard. But like I said, administratively, we treated this exactly as the
This is the
closest
route to
one and the
appeal.
most recent one, right?
I mean, I think they have a right to signage on it. They have a right to put it in a residential district, and what we have is a puzzle that doesn't come together and allow that. So there's the variance.
Your other approach may be, is it reasonable? Is what they're asking based upon a Dover use within a residential zoning district? Is the proposed signage, the amount, the size, the type, is that considered reasonable?
Yeah.
So this would conform in a business district.
Very likely.
And you say above grade. Let me just look at the measurements again, I'm sorry.
Can you go back to the packet, like, what is the one specific sign, the 30 or the 20 foot? there's a lot of numbers here.
That's the overhead at the center.
So which,
Does it say
The chart, are you referring
like,
to the chart
on the
or
building,
these-
like, where is it
That is a
on?
20-foot sign right there, the Gardner School.
Yep.
And the main entrance, and that will also be over here, which is in the parking area. It cannot be more than 20% of the whole area, which it is not. I mean, it can't even, it doesn't even.
Those are applying commercial standards.
Right, and we don't have that luxury either, because it's not commercial, but
Yeah,
using that as a
50% of the front
benchmark.
wall of said building or 60 square feet.
That's the sign that's looking for the variance, the one in the middle on the facade, is that correct?
I think all the
Sign
signs
is in
need
total,
variance.
all of it
If you
in
want me to-
total.
In a residential district, we're allowed 9 square feet.
Yep.
We are, as you total up the 3 on that table, I think it's 80 square feet, which is exactly what's allowed in a commercial district.
And they're
These
not
are
allowed
the
lit.
size of a commercial building if they were to be in the zoning, the commercial zoning district.
Well, the other part is the monument sign. I mean, it's within 15 feet of the paved road,
Correct.
but it's
'Cause,
too
yeah, it
close
says
to the,
allowable 20
okay, the term escapes me, I'm sorry.
Whichever is
Line,
smaller.
yeah.
Divided by 2.
But I mean,
They're on different.
where the
You have
paved
this
road
elevation
is
and you have
now.
this
So the
elevation.
code reads 15 foot from the street line.
Right.
Beg pardon?
So it's not, so,
But in a residential, they can't be lit. That's the other.
Yeah, that's the thing that's got
Yeah,
me.
we've closed the hearing to discussion. I think that might have been a little premature, so
Oh.
I could get a motion to reopen the public hearing.
Motion to reopen.
Okay.
Second by Peter. All in favor?
sure.
Opposed? Seeing none.
I thought
Becky's
Jose
a
was gonna address
stickler.
that, the setback.
No, I just wanted to
See, freestanding sign, front yard, lot, not exceeding 5% of front wall, 40 square feet for a freestanding sign.
And you're allowed one,
Right.
which is what they have.
I guess to do
It's a business district though.
show my cards kind of thing, it feels like the signs are reasonable for a building of that size. And if it was a commercial building or in a different district, it would be,
They wouldn't even be here.
right, it'd be fine. And it's allowed to be where it's going, so it seems to make sense that it should have the signage that's
I mean, that
appropriate
you-
for the.
And we've already set, again, these precedents, I struggle with them, but we have set precedent with the Primrose School, and that's exactly what we did with them, is we allowed them the commercial limitations, which is where they're at as well, so. it's
With
kind
the
of a
same amount
balance
of illumination, do you remember? I mean,
I
that's.
do not. I don't know
That's
if
one
it
thing
was
that I think
even,
with homes on either side and in front.
We did, I don't know that we got into the depth of that, but I know that,
What's across the street from this, like how?
Houses.
Houses.
Yeah, but
Residents.
how far, like,
Right in front.
Right in front. And then there's
Directly in
houses
front.
on either side as well.
If I could, we're set back building-wise, at least 75, 80 feet from the right-of-way. There is a street light right outside, which will project more light and then our sign's illuminated.
well, I mean, that's kind of what I'm trying to get to, like, I understand where it is and the houses are across the street, but.
Well, I would
If-
look, just to give a perspective, I mean, not to disengage what you're saying, I drive by this place and I've seen it evolve from, that picture is not in any way, shape, or evolving what it currently looks like, because they've cleared and leveled and whatnot, but, I mean, road lights and road noise traffic, because North Road is heavily traveled, but, I do have concern seeing what this very large monument light sign's going to look like on North Road, especially in the late fall, winter, as we're driving down at 5 o'clock and it's pitch black. We're gonna see this huge monument sign significantly lit. I just wonder what it, I don't know.
I
So
didn't
it's
find it to be
6 foot
massive.
overall height, it's 6 foot, so if you want to picture, I mean, it's not like it's a 20-foot sign, it's
So
just.
6 foot taller than me, so. And I get it, it's not a pounding, tower, but,
Right.
I mean, 6 foot's taller than me, so.
But it's say you conform
Taller than my
to
vehicle.
town lumens though, right?
We will, yep. Yeah.
Just to be clear, they're proposing internally illuminated signage. not allowed in the residential zoning district. That's part of the variance consideration.
Mhm.
I think you all know how Primrose is illuminated. So that's part of your
To my
consideration.
thought, it's not offensive. I mean,
It's
it's
part of
there,
your, it's just, I'm just
reality,
making it
but it's
clear
not
that that's part
offensive.
of your consideration.
So if you wanna look at this, the picture again, they're a halo lit letter, so the light does not shine through the face of the letter, the light only comes from behind.
It just
So
illuminates
it's
the letter, but it's not.
From behind, so
lit,
it's more of
yeah.
like a silhouette halo kind of
Back
effect.
shadow.
The faces of the letters do not light, but it appears there that they do, but the light comes from behind.
Yeah, that picture's not the best.
Yeah.
These are LED?
Yes.
So one way we've handled administratively for LED signs is Jose, correct me if I'm wrong, we've required the sign to include the dimmer.
Yep.
So that if it's installed and it's problematic, a nuisance, so to speak, meaning residents or abutters start calling, we at least have the ability to engage with the applicant
Can you turn it down?
to try to adjust it.
Because I don't think we've addressed LED in our light and our signage.
We do have LED standards.
Okay.
And I think they've indicated that they are going to comply with those. What I'm saying is that just because an LED sign complies, doesn't necessarily mean that it doesn't create a nuisance.
Right.
This is a unique a unique setting for an LED sign. So if the board is concerned that we just don't know, what I'm saying to you is we normally require that it have the manual adjustments. Most applicants are willing to work, reasonably with staff to provide adjustments. And that's on a case-by-case basis, based upon where the sign is located, where it is on the roadway, what are the surroundings, things of that nature.
And this has a street light directly above the sign? Or
Yeah,
within?
five
yeah,
feet
yeah.
off to the side, but
And that's gonna illuminate regardless, and it's also gonna illuminate the sign.
in some capacity, yes, not its intent.
Where'd that picture come from?
Well,
They
street light
These-
is different.
Yeah.
But these are what we have installed in Weymouth.
Is that the closest illuminated sign you have from here?
You may know better than me, the other one would be Dedham.
I'm not originally from Massachusetts, so I probably would not.
Yeah, Dedham's
They
closer.
might.
Dedham's
Dedham's closer, okay.
I don't find that overly bright or offensive at all.
I can't tell from here.
And I think
am
the
not
picture
best.
kind of blurs it a little bit, it's a very
Yeah.
clean.
No, you can't tell.
Yeah.
No, I mean, I've seen signs similar to this, I know.
On another, has there, probably, I'm just asking for my own, has there been a study or an analysis to make sure that this doesn't become a driving obstruction, like for turning, for your people coming in and out, for people driving down or has to turn, watching traffic flow? This doesn't become a visual traffic obstruction for drivers?
I can tell you that DPW and police, as part of their review, look at sight distances.
Okay.
So if you look closely at their exhibit, the stop line leaving the driveway is protrudes further than the sign face. So that has been looked at from a driveway safety perspective, sight lines.
I'm just wondering if like people are coming down and your stop line and people are trying to turn out and people are driving down North Road, are they gonna be able to know that people are trying to get out are not blocked by the sign so that you end up having T-bones coming out because someone was trying to come out of the driveway and someone's driving down North Road and they didn't see each other because your sign blocked them,
Well,
so.
you can see that you can see the sign placement relative to the stop.
Yeah, I mean, if you look at the thing, it does not,
Yeah.
I mean,
the
the
sign
monument
is
sign-
above it
Yeah.
by 10 feet.
It was on the site plan, site triangles were part of our whole planning process, just the details of the sign weren't. I'll tell you that the one in Weymouth, we have had some complaints, so it was on our radar as a concern to make sure parents have visibility, especially in North Road with our talks on traffic and things like that.
It's a busy road.
And very, very busy. And kids walking bus stop because there's a bus stop and crosswalk.
Any more questions?
I mean, as long as if they're open to a dimmer and open
absolutely.
to, if we get complaints.
Yep.
That sounds like a motion. We first need a motion to close
Yeah.
the public hearing once again.
I'll make a motion to close the public hearing again.
Second.
Second by Stephen. All in favor?
Yes.
Opposed? Seeing none. So regarding that
Right.
motion,
I thought you were doing it, Jan.
Oh, I guess I will make the motion. I will make a motion to approve the variance for 150 North Road for mounting signs and the monument sign and all other relief necessary in accordance with section 195-31.
and I
And
suggest you
all
add the,
letters, all
that
letters
it be
read
a,
in,
dimmable.
and in addition, adding a dimmer. And if we have an abundance of complaints, the applicant is willing and will adjust said lighting to respond to said complaints and concerns from the community.
Second.
By Charlie. All in favor?
Aye.
Aye.
It's unanimous.
Thank you very much.
Thank
you.
Hey, good one.
Thank you for the clarity.
Yeah,
It's crazy.
3.
The next one should go real quick.
For two?
Christmas.
There's 5.
Our next application
it's
is
early.
12 Colonial Drive. Patrice Sawchuk, I hope I'm getting that right, getting a special permit
Yay!
under the zoning bylaw, section 195-8.
Not Patrice Sawchuk. That's okay.
Nonconformity for construction of a farmer's porch that will increase the pre-existing nonconforming percentage lot coverage and other reliefs deemed necessary. This property is located in the residential RB district. Good evening. I got your name and address for the record.
I'm Deborah Sawchuk. I also live at 12 Colonial Drive. I'm standing in for Patrice. She's traveling out of state and couldn't be here tonight.
Fine.
But she is watching.
She is watching.
She's watching. And
And
she's
glad she's not here in
and
this long
she's
meeting.
able
She's
to
like-
answer questions if you have any.
She's gonna owe you big now.
Yeah.
She is. But I think there's a promise of dinner in here somewhere. for
Every
us.
more than dinner.
I win.
Dinner cruise.
After this long, it should be the Bancroft, right?
Going to the Encore.
Okay, so what do we got for dimensions?
Do you want to explain? Do you know the? Colonial Drive.
It's somewhat across the street from the
This is
school.
across the street from the school.
To block the lightning.
Why is it so cold in here?
Oh, did it come up?
Here's Jose's letter.
Rainbow. North. Oh, it's down the street. She's got a
Right on the
couple of them.
cusp, huh? This is from the building commissioner, Jose Negron. Mr. and Mrs. Sawchuk, please be advised the proposed farmer's porch addition at the above regarded address exceeds the pre-existing non-conforming building coverage. You'll need a special permit from the Board of Appeals if you'd like building coverage relief. Please make the application to the Community Development Department within 30 days of this notice. Thank you. Respectfully, Jose Negron, Building Commissioner, Zoning Enforcement Officer. The site is 0.4 acres.
15, 16, really? Oh, she's already non-conforming.
She's already non-conforming.
But the garage already bumps out. She's not even. See, the
Right,
garage
she's not,
already bumps
she's
out.
not, there's no further
Yeah, yeah, yeah.
non-conformity, it's the actual area.
But I mean, like, she's not protruding, like, there's already
She's
a
not,
protrusion
there's
really
not
on
a
the
further
building.
non-conformity, correct.
Yeah. she's really only covering it.
It's not for setbacks, it's for percentage of
Yeah.
lot coverage only.
I'm just saying from looking at it, like,
The existing is 16.8, and then with the porch, it's 18.5.
And the allowable is 15.
is there a slab there right now? Like a full extended slab, or is it just like stairs under front of her door?
There's
It
just
looks like
stairs
there's
in
an
front of
existing
it.
set of stairs right there.
Right.
I mean, this is just, I think, they're required to have it, but I don't think this is any kind of problem, personally.
It's gonna look good when you're done.
Departmental letters.
Are there any questions of the applicant?
It's straightforward.
Very much so.
We're just gonna read some
I'm gonna
letters.
speed read the letters. Who is this from? Oh,
DPW.
yeah, of course it is.
It's late.
12 Colonial Drive. The proposed farm porch will be near or possibly over the existing sewer service. The applicant must contact the DPW Sewer Division to coordinate any necessary actions to preserve or alter the sewer service. 2, erosion control devices must retain the sediment on site. These must be installed prior to any work or earth disturbance. It should be noted that the property is located within the Aquifer Protection Zone 2, and Conservation Commission should coordinate it as necessary. Consideration should be made to install roof drain drive wells to the proposed farmer's porch to keep the stormwater runoff within the property. This is not a requirement for approval. This is from the Fire Prevention regarding 12 Colonial Drive. They have no concerns. This is from the Chelmsford Water District regarding 12 Colonial Drive. They have no concerns. This is from the Police Department regarding 12 Colonial Drive. There are no concerns. And this is from the Treasurer Collector for 12 Colonial Drive. There are no concerns. It's from the Board of Health regarding 12 Colonial Drive, and there are no concerns. That's the extent of my letters. And those is. Open this up to the audience and see if anyone would like to speak in favor or opposition to this. Nope.
It's getting too late.
I'll make a motion to close the public hearing.
Second that.
Everybody's.
Second by Charlie. All in favor?
Aye.
I make a motion to approve the application to build the farmer's porch.
That's not, yeah, to increase the existing non-conforming percentage of lot
For
coverage.
195-8 for 12 Colonial Drive.
Respect all the letters.
With respect to all the letters, thank you. Stephen?
I'll second that.
Second by Peter. All in favor?
Yes.
Good luck with that.
Jamie.
Opposed? See, it's nice at the end. We're so tired.
Let her know, congratulations, she has her special permit for a porch. Thank you.
Did you even make a presentation?
You'll be lucky to get to
She
Arby's.
beelined it out of here.
Yes. She's
I
gone.
think Brian wants to go home.
Efficiency.
special permit.
Efficiency.
No, we just hit our stride now.
Just approving.
Did we get the hard ones done?
I think we're
Yeah,
through the
hard ones are done.
128 Warren Ave, owner Gail Smaldone is requesting a special permit under the zoning bylaw, section 195-8E2, nonconformity for construction of an attached garage does not meet the side and rear setback requirements, nor the percentage lot coverage threshold, and a variance exceeding percentage lot coverage for section 195-9 and other relief deemed necessary. The property is located in the residential RB district. Good evening.
Good
Can I have your
evening,
name and address for the
Chairman,
record?
members of the board. Thank you for hearing our petition here. I'm representing Gail Smaldone. I'm her builder, Paul Catalano, and our company's Catalano Construction. We're out of Westford, Massachusetts. I've been working with Gail for about a year now, trying to place this structure. And the reason why she needs this structure is because
and I'm not sure if this applies or not, but this is why we're humbly asking for your approval, is that if you could consider her lot, the shape and topography a hardship, would also have to ask you if there's any way that you would consider any other hardships. And in this case, Gail has medical hardships where she's had open heart surgery a year ago and is under advice by her doctors not to do anything of strenuous activity. And she's unable to find help in the winter to clear her car of ice and snow. She's able to get her driveway plowed, but she can't find anybody to salt and break the ice and so forth and so on. And she's concerned about her mobility, being able to get out and about. She's a lifelong, since age 5, resident of Chelmsford and a staple of the community, a former a teacher's assistant in town, and just an all-around good person that I think deserves the board's highest consideration for not be less than a difficult placement of this structure. Thank you.
Since 5?
Since
Been here
5.
since 5 years old.
1962.
So you're a fly-in, just like me.
A blow-in.
A blow-in.
Blow-in.
Right, yeah, it's very crowded. Thank
Go
you.
ahead and zoom in on this.
Yeah,
So
where is?
the
I've only been here
lot-
40 years.
This is the
and sometimes
garage
I
that
get
they're adding.
crap for that.
Is this the plot?
That's the lot line, 100, see, yeah, that's the lot line.
So the shed's already at 12.
I'll pass this
This
down
has
along just
nothing to
look at
do
the
with
lot
this, but I
lines a
just
little
want
bit
you to
better.
know my
Although
wife
this old
found an
plan
organization that
does not have
helps
the current proposal
elderly
on it.
people
That's
in the
not
winter
location
time
of
to
the
do their
garage, just to give you a
driveways and
visual of
stuff.
the
Be happy to
setbacks.
give you my number, and that's nothing to do with this. And if she can find this organization again, be happy to share it
And
with
then
you.
the change, the lot coverage.
I understand, we're facing the same thing.
Yeah.
I don't see where that,
It actually wasn't put on the plan.
yeah.
Oh, none of it was.
Coverage, existing lot coverage is 5.7%.
Proposed lot coverage is 16.7.
Oh, there it is. It has nothing over 15, right? Yeah.
Correct, so it's 1.7.
But we can still do a special on that, right? Can we do a special on that?
In there, okay.
It's the fall that we can't, right? 10%?
That's a variance for exceeding the percentage lot coverage
That's
by 1.7%.
Yes,
All right.
that's how I wrote it up.
Special
It wasn't
permits.
clear at first when it was applied for whether or not it fell within the pre-existing nonconformity or not, because the plan shows the proposed lot coverage, but didn't show the existing. So I wrote it up as such,
Okay,
so that the legal notice would include both in case both was needed.
okay.
Right.
Because I was unsure of whether or not it would all fall under special permit.
Okay. But we definitely need the variance for the lot coverage. Cause this one says 5.7.
For existing. I don't think that's I don't think that's accurate.
It looks kinda
It doesn't-
small.
Yeah, I don't think that was
That's not correct.
right,
Relocated.
because the garage is small.
That can't be right.
20 here. This is 16 and a half. 16 and a half by 28 is the proposed garage?
16 in the front, 28 down, but 16, 5 and a half, so that it comes
To
flush.
carry the back
Yeah,
wall there?
carry the back wall,
Yeah,
correct.
Okay,
This 20 by 22, is that?
that's not.
That's not.
Oh,
So
okay,
I-
okay.
Oh,
I
okay.
explained that plan is just so you can see the setbacks a little
So
You
bit.
get a better look at the
5.7
setback.
is current.
But
So
the
the-
garage is going next to the house. The
Right.
garage size is 16, 5 and a half in the rear, 16, even in the front, which just allows you support on the back wall carrying right through. And then the overall length is 28.
And what year are we in?
The location of the proposed garage is on the larger plan. The letter size one was just so you could see the current setbacks a little bit better.
Right. So they're already non-conforming. 12 and a half, yeah, okay. Variance. All right, master builder, is that about a right size for one car?
Which date is on?
No, it wouldn't be any smaller. It wouldn't be, you know, to be able to open your doors and, you know, it's,
Comfortably getting out.
yeah. And what, you'd have to get rid of one, what is the lot size, 10,500, so you'd have to get rid of 105 or something. It wouldn't, you wouldn't get away with it. You wouldn't get to, you couldn't shrink the garage and accomplish that.
Oh, and she's adding a deck too. Is the deck part? Deck's part of it?
The deck is part of the, yeah, the coverage area. Which is 120 feet.
Yeah. That's pretty big.
I mean, it's a deck. It's probably a smaller deck as you get away with and enjoy. Certainly not oversized.
Nope.
I'll look at it, I'll read the letters and regarding 128 Warren Avenue, the conservation, the project will require a notice of intent filing with the Conservation Commission. Chelmsford Fire Department regarding Warren Ave, 128 Warren Ave. Dear members of the board, regarding the special permit request for 28 Warren Ave, this office issues the following requirements and recommendations. In accordance with 780 CMR 51, a heat detector shall be installed in the new garage. This detector must be hardwired and interconnected so at least one device located within 20 feet of the nearest door to the garage. This is the minimum level of protection required. This author further recommends that the entire residence be upgraded and hardwired interconnected smoke system with carbon monoxide detection throughout to provide a higher level of life safety protection. All plans are required to be submitted and reviewed by this office as part of the building permitting process to ensure full compliance. I request that this letter be made part of the public record and incorporated into your approval process. Sincerely, Josh Abbott, Chelmsford Fire Prevention Office. I have a letter from Sheila Joyce, project engineer. Request for determination. As proposed addition will be near or possibly over the existing sewer service, the applicant must contact the DPW sewer service to coordinate any necessary actions to preserve or alter the sewer service. The DPW has no concerns regarding the location of the proposed driveway extension. A licensed contractor must apply for an ROW and driveway permit for the DPW prior to the start of work. Erosion control devices must retain the sediment on site. These must be installed prior to any work or earth disturbance. It should be noted that the property is located within the aquifer and the wetland buffer zone, and the Conservation Commission should be coordinated with as necessary. Consideration should be made to install roof drain dry wells to the proposed garage to keep stormwater runoff within the property. This is not a requirement for approval. I have a letter from the Chelmsford Water District regarding 128 Warren Ave, and there are no concerns. I have a letter from the Police Department regarding 128 Warren Ave with no concerns. I have a letter from the Treasurer Collector for 128 Warren Avenue with no concerns. I have a letter from the Board of Health regarding 128 Warren Avenue with no concerns. That is the extent of my letters. This time, I'm going to open it up to the audience and see if anyone would like to speak in favor or opposition to this application.
Would it be possible to submit a letter from the South Halls, who are the neighbors to the north?
Certainly.
Of, okay. Unfortunately, I wasn't able to make 10 copies, but Ms.
Well
Selko
done.
was here, but it had to go, so if I can leave that with you, sir?
Yep, thank you. The letter states, I am Linda Southall, and along with my husband Hugh Southall, live at 2 Lawrence Circle, which abuts the back of the property at 128 Warren Avenue. We have lived on Luan Circle since 1979, except for 4 years while stationed at Andrews Air Force Base in 1983 to 1987. We've enjoyed a very friendly relationship with Gail Smaldone during all those years and have no objection to the building of a garage on the Smaldone property. It will be helpful to Gail to have a garage given her health issues and how increasingly difficult it has become to find someone to clear automobiles of snow during the winter. Thank you, Lynn and Hugh Southall.
We did receive an email from the direct abutter to the left of the property at 124 Warren Ave. In speaking with him, he did state to me that he has no opposition to the garage itself. He just has concerns with the, where it's located. And I have the email attached to the agenda. I'll pull that up and I'll have you.
I noticed there's a difference between the 80-foot and 100-foot between the old
and that's
and
the
the new.
revised that you just received today. That's not what was posted on the agenda, so that was a correction to that, which I brought to the applicant's attention.
Is it 80 or 100?
It's 100 based
It's
on all
100.
the deeds, because I
Okay.
actually looked up all the deeds, so it's 100.
It is
so
100
it's corrected
feet.
now, yeah. The,
But I noticed I noticed the measurements are the same. Either like the 12 by 2, it's still 12 by 2.
So this is the, if you would like to read it into the
Hi,
record.
Becky. I have attached the plot plan deed and private easement for 124 Warren Ave, Chelmsford. I have reviewed the submitted copy of the proposal and have several concerns. The submitted plan shows a boundary line between 124 and 128 is 85 feet, while both the attached plan and the quitclaim deed show a boundary of 100 feet. The proposed plan also indicates that the driveway of 128 is on the property of 128. If that were the case, the attached easement for adding the driveway would not be necessary. I suspect that the proposal uses an incorrect plot plan and inaccurate estimates of the setback for the proposed structure, as well as its location relative to the easement, which only grants improvements of a driveway and a garden. Any intersection with the garage and the easement would require the easement also be modified. Although not required, the site plans for a setback variance or special permit should also include the location of the tree line. See attached picture. I am likely unable to attend the hearing due to travel. I will have to make for Seattle for work that week, but I would like to voice my concerns with the proposed plan. If any other information is needed, I am happy to provide it. Regards, David Keeley DeBonis, owner 124 Warren Avenue.
Then he did send another reply just to clarify that in his email when he referred to the 85-foot lot line, he
Actually,
had a
80.
typo, was 80.
Okay.
So the original plot plan that was posted on the agenda and still is on the agenda had 80 feet on that side. Can I hold this up? On the
Sure.
side, on the left side of the property.
Okay.
And the applicant, the contractor revised it this evening and submitted it to show. I did look up the deeds and everything, the deed on the easement, the deed on the applicant's, the applicant's deed on her property, everything states that this is a 100-foot line. So I think that was a typographical error based on the opposite side.
Right, this got married here, and then
Yeah.
he just made his own mistake.
I did not have an opportunity to upload all of the attachments to the agenda from this abutter, but I did bring digital files so I can pull it up for you. Let me just grab those now. Let's see. Just a second. Hold on just a second.
Just gonna ask Jose. Jose, are you of the opinion that it is a variance at this point?
Mr. Chairman, based on the shape of this lot and the proximity to the house next door, I'm of the opinion that it's a variance.
Okay, I just wasn't sure where the dust settled with the change in dimensions and such.
So the concern is there seems to be some misunderstanding in terms of where the easement may be located. The revised plan shows it based on the plan of land for the easement, but the abutters, his email, he's concerned that the existing driveway that's on the property is the 25-foot easement that was granted in 1994. In speaking with the applicant, she thought half of her driveway was part of that easement, and then the other portion goes, it just wasn't clear where the easement was. So they've submitted a new revised plan showing the easement on the left side, all 25 feet being beyond that 100 foot.
At the edge of her property line,
Right.
which is, so,
But the existing driveway is 25 feet, and I think that's where there is some, needs to be some clarity for both the applicant and the abutter in terms of whether or not all of her existing driveway is in her property or some of it is part of the easement as was described, because the easement the purpose of the easement was to have the driveway and a garden. I'm gonna pull up that for you now, just so you can understand what I'm referring to.
have you reviewed the easement, by any chance, Jose?
I don't have any jurisdiction over it, yeah.
Yeah, this just,
I think I would suggest that we get a plan that shows, a stamp that shows the easement.
so I have that.
We do have it, oh, great.
Based on what was recorded at the registry.
And it's
Just give me a
stamped.
moment, sorry about that. So there's the actual, what's on here is the actual description of the easement that describes that it's 2,500 square feet, and why it was created.
I'll just read this out loud, if that's all
Yeah.
right.
I was just trying to highlight
We,
that.
Dale D. Crandall Jr. and Dale D. Crandall Sr. of Chelmsford, Massachusetts, the heirs, executors, assigns for in consideration of $2,500 paid, grant to John C. Smaldone Jr. and Sylvia A. Smaldone, husband and wife, as tenants by the entirety, and their heirs, executive, and assigns the permanent right and easement running with the land to forever use, enjoy, and maintain the land together with improvements now thereon, a driveway and a garden, exclusive of the clothesline poles, the following described parcel of land. 2,500 square feet, more or less, is shown in the plan. But do we have an actual
Yes,
plan
I have
to?
the
Yeah,
plan.
good.
And the
This is the
garage is not
recorded
in the
plan.
easement.
That's the one I think we want.
So the plan itself that was recorded in February of 1994 shows the abutter's land. So this is his
Property.
property, which is to the left. And it shows a 100-foot line, which looks consistent with the certified plot plan that we're seeing.
Yeah.
Goes 100 feet
Right, the
straight
accurate 100,
north,
okay.
and then takes that somewhat 45-degree angle.
That's this
Oh,
right
yeah,
here.
right
Let
there.
me enlarge
Yep.
this for you.
And then at 25 feet out from the turn, right before it pitches.
Right,
Gotcha.
okay.
And that easement doesn't give them any rights as far as setback.
A situation like this, I think this is all new information. I will have to probably consult town council on that and see what he's, because it's really legal.
I think it's a possibility that we should consider. So if that easement is considered your property, which, let's say there's an argument there, you wouldn't need the variance.
That's correct.
So I'm gonna suggest that we continue this and let Jose do some work, and perhaps you speak with Mr., I won't even get this right, Terrazzoni, and see what you can find out about the easement, and if it is in fact suitable to use as a setback, you won't have to reappear. You'll be able to move ahead, and you'd get approval from Jose.
That'll help with the land coverage too, right?
That would reduce the land cover by 2,500%, yeah,
You
that
won't,
would
you
be.
won't need a
Yes,
variance
it
for the
would.
land coverage either.
That would be great.
I mean, you
This may
might
be
not,
very-
that land is yours to only use
To only
as a
use, not
driveway,
owned.
As a
but
garden
it's
and a
still
garden.
theirs to use, so it could
Correct.
still be
For eternity.
calculated
Yeah,
in their
that's-
land
That's
process.
definitely too bad we didn't have
Even though
Jonathan
it's
still, yeah.
restricted to what you could use it for, it's
Mhm.
still theirs by right to use
Right.
with the
For
restriction.
eternity.
and you maintain it, they paid for it, so it's your land. You're restricted to what you can put on it by their agreement, so it should be able to be used in your calculations. So land coverage and setbacks, I can't see why it wouldn't account for
You
you.
probably wouldn't need to come back.
You paid for it, and by legal right, it says you own it.
Yeah, I think that would be great. And I'm sure Jose is gonna take that up as well.
And then you wouldn't need a variance or special permit, because it would cover your land coverage and your setback.
May I ask a question?
Oh, sure.
Okay, so if that winds up being the case, then
You conform.
that whole 25 feet is the side setback?
Yeah.
So if she wanted a little more garage, no way, okay.
Because you can only use that easement for the
No, but I mean,
driveway.
you couldn't go into the easement, but you go up to it,
You
no?
can-
I know, take
We
it,
didn't
ask
say
for an
it.
inch,
We don't
take a
know.
mile, I know,
If
but
council
I'm
agrees,
just,
yeah.
you know, curious
I don't know.
what you guys think about that.
Yeah, the easement would count as part of the setback, right?
Right, and so the clarification we need as well is the abutter may have misunderstood where the lines were and thought that the easement was the existing driveway because the language refers to a driveway.
Yeah.
And his concern is that the garage would be put in the easement, not
Yeah,
within the property.
In
They
this
think
survey,
the
but there's
easement
no.
is the driveway
Oh, okay.
already.
All right.
Yes.
But that's showing that the easement is next to your already existing driveway.
It's next to it?
Section of the driveway, a very small section.
Is in it.
This,
In it.
Right.
this red
He
line
thinks
is
your
noted
whole
here.
driveway is in it.
He's new, he's been
That's
there
the
just about a
25 foot
year.
wide.
Ah.
He didn't.
That's new
he
to
didn't
that, yeah,
know
yeah,
the
okay.
property line or that piece that
There
was
it is.
there is
The-
actually
his
his.
neighbors
I
knew.
had to tell him
The neighbors
that this
knew.
is your land. I maintain it because of the easement, but
Actually,
all
It's
of the
not-
la-
it's
It's
not
not
his,
his.
it's yours, you have an
It's
easement
yours.
for
It's
it.
yours.
Yeah.
It's yours.
Yeah,
You have right to
You paid
use
for
it.
it.
You
You're
have
right.
the right to use it.
but I
okay, it's good.
okay.
Yep. We'll get an opinion, we'll get an opinion from council. but
When
the
you win,
easement-
stop talking.
It's kinda like.
She's honest to a fault. Stop.
It's the right
To use and maintain.
Right, but what we need town council to clarify is the right to use is, there's,
Does that include the setback?
Yeah.
right. I don't know that would apply to the setbacks because it's not her lot.
Yeah, we'll have to
It's
see
not
what
within
council
her
says.
lot.
Okay.
Question for an
Let's see what
attorney.
council says.
Right.
So we'll do that.
There's a possibility.
Okay.
Council, we'll get the lawyers involved, they know the,
I'm
that's what we
gonna
get
ask
paid
if
for.
anyone would like to speak in favor or opposition to this application, so that we're done with that if they do not come back, so, anyone? Yes, sir? Please approach the podium.
I'm not a neighbor, and Hushman Afshar, Taj Engineering here in town. I just want to mention that I'm a licensed land surveyor. Setbacks are measured from property lines, not easement lines. That's all I wanted to mention.
So it probably won't be helpful to her.
Whatever the setback is. The easement is intended for its intended use. You can't build on it. If it's a utility easement, if it is an access easement, egress easement, it can be maintained for that use. But the setback has to be measured from property line, period. Thank you, sorry.
Thank you.
Good to, okay.
One opinion, we'll see.
Yep.
So I'm gonna suggest we continue this till October 2nd, and we'll see what can come out of this, what, good or bad.
Okay,
Okay.
okay.
Is there anything else you'd like to say this evening?
Thank you for your consideration. Thank you very much, appreciate it.
I make a motion to continue till October 2nd.
Second that.
Second with Charlie, all in favor?
Aye.
Unanimous?
Thank you.
See you next month.
Thank you, have a good night.
You too.
And
National
here,
Variance
so
Day.
Glenn will be the alternate if he's present.
Yeah, let me check with my wife, give me a couple of days.
Good luck with that.
Jerry, you're not gonna be here?
I'm gonna be in Greece.
Just want you to know, I don't usually give my number to ladies.
Are you gonna be chair in Toronto?
Sure.
Thank you.
I'll study up.
Our next application is 25 Wilds Road. The applicant Joseph Luna of Luna Design Group, representing owner Robert Gordon, requesting a variance and/or a special permit under the zoning bylaw, section 195-8, conformity to reduce the front yard setback from the required 35 feet to the proposed 33 foot 2 inches, and expand the existing garage with exceeding the maximum percentage lot by 1.9% and other relief deemed necessary. This property is located in the residential RB district.
What is this?
Okay, good evening, board. Tom Petty, the waiting's the hardest part. So I hope this will actually be the case. All right, my name is Joseph Luna. I am the architect for this project. The company's name is Luna Design Group. We're out of Danvers, Massachusetts. It's a relatively straightforward project. Can we actually pull up the existing floor plan and proposed floor plan, explain some of the context of why we're asking what we're asking for?
I am freezing.
Architectural
I'm
plans.
sorry. I tried to endure, but we're going to have.
Okay, this is the existing garage right here. This is mechanical room. Several years ago, my clients, Robert and Janet Gordon, put in a new high-efficiency furnace. There was not room in the attic, and it had to be located in the garage. Because it was located in the garage, the building inspector at the time required an enclosure around that mechanical unit, so you could not have carbon monoxide in it. Problem with that, if you see where the garage door is it made the garage unusable. And it's been unusable for some time. My clients are getting a little bit more up in age and want to have an actual place to park. Can we go to the proposed plan? Oh, it's on the architectural plan, just the next couple of sheets up. Just scroll up, keep going, keep going. That's the existing elevations, one more right there. So this is the proposed garage extension. We're extending roughly 7 foot 7 inches from the edge of the existing garage to get actual garage door and making that mechanical room a little bit larger, so there's more surface area around it. Let's back up, go back to the existing elevation. You can also see on the front facade, and there's a photograph here as well, this is the edge of the garage. This goes back to pretty much an unusable space in the back. It's about a 4 foot high knee wall at that point. So even though the garage has some depth, because of the roof slope, it just continues down. It makes it virtually unusable. Our proposal was to actually change this, go up. Right here is to actually turn the roof perpendicular and get more usable space within inside that garage. It's still a single car garage, but when we start shifting everything over, we went over the property line by the setback line by 1.7 feet. And that's what the variance relief we're asking for. Also too, because of the expansion on terms of
The special permit, right?
the special permit,
Yeah.
we also are actually over 1.9% on the percentage. You can go back to the site plan now to give you a reference.
Shows land
So here's our 7.6 feet, 7.5 extension, and our slight encroachment over the front yard setback, and then the percentages speak for itself. We would argue here that there's a legitimate hardship here because of the site shape. I could also argue the subsurface conditions because there's no basement to actually put that furnace. And that's the overview of this. My clients have gone to the neighbors and have spoken to the neighbors, and we have 4 letters of support. I'm happy to answer any questions from the board.
That's right. I mean, this is a special permit.
Land coverage is under 15. Building coverage goes from 15 to 11.
Land coverage is because of the driveway and the building.
Did you say you're raising the knee wall, or you're
No,
leaving it where
we're
it is?
turning the roof perpendicular. So if you look,
Okay.
We didn't want to be an extrusion of the roof, so architecturally turned the roof the other way, made it provide more headroom
That's,
inside.
I was confused on the elevation drawings.
Yes, yeah.
I was asleep, so.
I think we're all getting there.
It's already non-conforming.
I was supposed to pick up 5 pounds of potatoes on the way home.
It's a special permit.
I think that's gone.
We advertised it as either or, because again, it was a little unclear as to whether we were creating a non-conformity or not. But that section does say, or that's always been the gray zone as the board was interpreting it in the past, which is why I wrote up the legal notice as one or the other, that I believe it may one of these special permits.
That's, I believe, too.
It's section 195-8 for nonconformity, but then it's subsection E2. Yeah, E2. So underneath the chart there should be number 2.
I don't have any.
Special permit.
Is that the old book?
That's the new book.
2024.
No, that's okay.
Special
This
permits
is-
for non-conforming
this is
single-family
section E,
residential
and that's
structures.
The special permit is simply for inside the aquifer protection district.
Right, that's where the
Right.
lot coverage comes
Which
in.
we see the maximum lot coverage by 1.9%.
Alter or change, increase. This one, I'm just wondering, because it only references the front side and rear side. Oh, here it is. Other dimensional requirements to a structure which also complies with current building code.
Took me a second to remember how I know your road. I have a friend who lives on Parley.
Yeah, we've done that before, and it's gone back and forth with
The following features shall not be deemed to increase.
Right.
Conforming
Those
nature
are
of the
historic
structure.
setbacks,
to historic.
which is what we're using here.
Right, the 1735, is it?
Yep, 1735.
Because it's as big as 35, I mean, it existed on the 17 or something.
Complies with
1140.
and also complies with
So we're on the
current
7, right?
building code.
But then the question is whether it falls under
Yeah, 'cause
number 2,
D-
which is separate.
I think we did this before.
What's the current building coverage?
Current says
Mm.
15,
That's
that's
required.
required.
11.4.
That's
It doesn't
That's
give us-
proposed.
Oh, that's a max building coverage, I'm sorry.
Area measured,
Right, they didn't give the existing,
no
it just gave
experience allowed for
required
use,
and proposed.
land disturbance.
That's a question to ask if he knows what the existing percent coverage is.
Do you know what the existing
No,
plan?
that was done by the surveyor in that table, and I don't have that information for you.
Are you looking for the existing building coverage? That will be 15%.
The existing
No, no, no,
allowable, but
I'm
not
allowable.
the actual.
Not the allowed, the
Oh, I'm so
existing.
sorry.
Yeah.
I thought you were.
The chart doesn't say what the house is now.
Because I can't
it says
believe
what
that,
it
I
will
see.
be.
I can't believe that
Possibly.
extension adds.
It's at 1.9%, right? So you just do a deduction the other way.
You can take
It
that out
has
of
to be
the,
under, it already has to be over the minute. If it's only due one, it has to be over the limit.
Right, so
So
if
it's
it's
already
already over the
non-conformant,
limit,
okay.
then it's pre-existing non-conforming with law
Probably around
coverage, so you can put it
13.
all under the
Under
special
two,
permit.
yeah.
Right,
It's
so it's
already
all special
non-conforming.
permit.
Right.
I had put
Quick.
the language in the legal
Yeah,
notice,
it's already
because it wasn't
non-conforming.
clear initially,
Yeah.
Okay.
for one or the other, just to be safe, so we wouldn't have to repost it.
So it's already not, all of it is already non-conforming.
I believe so.
Right.
We are
That's what I'm-
adding 194.56 square feet to that garage, which obviously increases the percentage of coverage. And I think we can kind of work back from that. Yep,
Permit says you're going up by 1.9%.
Yes.
Right.
Request.
Just add that.
Right, just back it up. That's what you did,
yeah, so we're adding 195 square feet, let's call it.
And the year built,
61.
30.
So the
So it's-
next building coverage fall under special permit, but it's already non-conforming, is that?
It's a pre-existing non-conforming on lot area and
Front and side.
frontage.
Front and,
But now we're creating
Rear
new
setback.
non-conformance in the front setback.
front and rear.
Yeah, so
setback.
you're, if you take
But
the
it's under
3801.9, and I said we were adding 152 square feet,
Right, you're gonna
the
get-
existing lot coverage is 3,649, so 3,650 square feet, so it's already non-conforming on the percentage of lot coverage.
Right.
Right, we figured.
So
Which
that's
makes it a
what-
special permit.
Yeah, so it's a special permit in that respect as well.
But it's, what year are we?
I think 61.
73, I think it was.
Is this year built? 60. Year built.
1960.
60, yeah.
Yeah, it's written.
1960.
17 and 30.
Front is
30 or 35?
30.
Sorry,
35.
35.
Okay, okay.
And then the sides are
Yep.
17.
So it's gonna reduce to non-conforming. Yeah, reduce non-conforming. The front's gonna turn to non-conforming.
With a special permit,
Right.
because it's under 20%.
Right.
Same with the rear.
Letters?
Yep.
Butter letters and the department.
There's something wrong on the rear?
No.
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 I think that might have
So
been a
that's
typo.
greater than, I
Says
don't know why they
35.
put greater than and not the setback itself.
Yes, so the current area in terms of required is 3,375, and we're at 3,607 as present. And we're adding a total of 195 square feet to that garage. So just working the math backwards.
Yep. That's fine.
So it's
I
already,
don't think Stephen could take another variance.
so the only thing that makes
We
it,
can't, right.
the only thing that makes it non-conforming is land coverage, is lot coverage, because it's already currently.
And the extension into the front.
The extension.
No, prior
But
to
it's
the
still a special
addition,
permit, it's under 20%.
prior to the addition, it met setbacks.
Yes.
Right, so we grant a special permit, which is less than 20% of the setback itself at 35.
No, because it,
We can't do it based on 20% reduction, because that's for conforming structures.
because it
But you
wasn't
can do it,
conforming.
but you can do it under, I believe, and this is
For discussion.
your discussion and your decision to make, whether or not you can do it under nonconformity 195-8E2. Because,
The
you
building
know,
commission determines.
it is a pre-existing
Cannot be issued
nonconformity.
per section E as a nonconforming would increase by proposed construction. The board may
allows
do a
increases.
special permit,
Mhm.
such extension, alteration, change, or determine the proposed modification will not be substantially more detrimental. So we can do two.
You would do it under that
Because it's
section, not the 20%
Yeah,
reduction.
that's the way I
because
thought we
the
did
non-
it, Brian.
I think that's what we were
I
looking for.
mean, this is really
Yeah.
inches here.
It is.
This is not, this
We
is
just
not.
wanna make
And
sure.
that's why that section was in there, was to give that wiggle room for the pre-existing.
I think I was just looking, where's the nonconformity, but it's the land coverage that's currently nonconforming. Because the setbacks, they make it.
And the pre-existing nonconformity are the setbacks.
No, pre-existing.
Pre-existing non-conforming.
The
Right.
setbacks, it does make setbacks for pre-existing.
Setback is conforming.
Right.
Which is why our extension over the setback line requires a variance, and we argue hardship on that.
No.
No, we're still gonna do the special permit.
That's what we're saying. So because your pre-existing building land coverage is non-conforming,
Everything's non-conforming.
your whole building is non-conforming, your lot. So we can give you a special permit for your setbacks. You don't need
I
a
will clarify, the setback itself is already pre-existing non-conforming based on 35 feet instead of the current 40.
The 40 that's required of
an because
an A
it's
lot.
already pre-existing non-conforming.
Right.
It conforms
Everything's
with the historic
non-conforming.
setbacks,
Oh,
but it's pre-existing
historic
non-conforming.
That's right, that's right. There are two
That's
sections.
why-
Houses built before a
that's
certain
why the-
time, you
yes.
get 35
Got
feet,
it.
current houses is 40 on them.
Got it.
So
What you mean,
that makes-
So that
standard.
still
That makes the
requires
house.
the
How about
variance.
those letters?
How about those letters, yeah. Let's not dig any deeper into this. Chelmsford Fire Prevention. Members of the board, regarding a special permit request for 25 Wilds Road, this office issues the following requirements and recommendations. In accordance with 780 CMR 51, a heat detector shall be installed in the new garage. This detector must be hardwired and connected to at least one device located within 20 feet of the nearest door to the garage. This is the minimum level of protection required. This office further recommends that the entire residence be upgraded into a hardwired, interconnected system with smoke and carbon monoxide detection throughout to provide a higher level of life safety protection. All plans are required to be submitted to and reviewed by this office as part of the building permitting process to ensure full compliance. I request this letter be made part of the public record and incorporated into your approval process. Sincerely, Josh Abbott, Fire Prevention Office, Chelmsford Fire Department. I have a letter from the engineering regarding 25 Wilds Road. Record sewer does not show any conflict with the proposed structure. 2, erosion control devices must retain the sediment on site. These must be installed prior to any work or earth disturbance. 3, consideration should be made to install roof drain dry wells to the pros addition to keep the stormwater runoff within the property. This is not a requirement for approval. I have a letter from the Chelmsford Water District regarding 25 Wilds Road, no concerns. I have a letter from the Chelmsford Water District.
Just being extra careful.
No concerns.
Water
No concerns.
Duplicates.
No, I didn't get one that time, which is really bizarre. I got a letter from the police department for 25 Wilds Road, no concerns. I have a letter from the treasurer collector, 25 Wilds Road, showing no concerns. I have a letter from the Board of Health showing no concerns for 25 Wilds Road. That's the extent of those letters. I also need to read in letters presented. And dear committee, our names are David and Ann Poirier, residing at 28 Wilds Road. Christopher Borden, residing at 23 Wilds Road. David and Norma Ruprell, residing at 30 Wilds Road. And David Hurst, residing at 27 Wilds Road.
David Hurst.
We are sending this letter on behalf of Robert and Janet Gordon, owners of 25 Wilds Road, Chelmsford, Massachusetts. We have reviewed the proposed plans prepared by Luna Design Group dated 1/3/25, and the proposed site plan prepared by Chess Engineering dated 1/6/25. We find the proposed addition attractive, compatible with scale and context of the surrounding homes in our neighborhood. We believe that the proposed design will have no adverse effect on our property or the neighborhood as a whole. Therefore, we offer our support for this project for the requested variances, special permits. Thank you. That's the extent of my letters. Going to open it up to the audience and see if anyone would like to speak in favor or opposition to this application.
Pace yourselves.
Don't all rush to the podium.
Seeing none,
I make a motion to close the public hearings.
and I assume they're in favor of it. Yes.
Oh, we have questions.
Yep.
We have a question from Steve.
Drawing, it says min rear setback, required 35, proposed greater than 30.
That means, yeah,
We're way over 30 feet.
Yeah,
Yeah.
because that's their historical,
okay.
Yeah.
right?
No, that's,
I don't know why it says greater than 30.
But like
We just
31
weren't clear why
would
it said
be-
over 30.
It seemed odd that it said greater than 30.
Yeah, it's-
That's what
yeah.
got me too.
Chess engineering's like.
This is the set,
I guess it should have said greater than 30.
35.
Yeah.
It might have just been a slight typo on there.
Good thing
these
that I
engineers and their typos, I've never seen
know.
anything like it.
That's what got me too. And I was like, why does it say greater than 30? I make a motion to close the public hearing, Chair.
I'll
Thank
second
you.
that.
Second by Peter. All in favor?
Any other questions?
Motion.
I make a motion to approve the special
Special
permit for
permits.
25 Wilds Road in accordance with section 195-8 and with all red letters read in.
I'm getting hoarse.
I'll second that.
Second by Peter. All in favor?
Aye.
Opposed? None?
Okay.
Good luck with
Good
it.
luck with your project.
So we're good, no variance required also?
That's correct.
No, just from,
Dan?
Nice and
Yeah.
easy.
Yeah, easy.
Have a good night.
Easy peasy.
Lemon squeezy. Enjoy.
Just a 2.5-hour debate on the ADU.
What can we say?
That was a-
Variances are a pain
That
in
was
the
tough,
butt.
boy. I'll tell you, I didn't feel good about the whole thing. Our ninth and last, Southgate Road.
Have a good evening. Thank
Have
you.
a good night.
Take care now.
Make a motion to approve.
Hey, Bob, take care.
Second.
Second.
Do we get special consideration for being last?
Somebody got a lunch out of it. I don't know.
Sometimes it can work in your favor, let me tell you.
So 6 Southgate Road, owner Kristen Lenardi is requesting a variance and/or special permit under the zoning bylaw, section 195-8E2, nonconformity, for the construction of an addition that will increase the pre-existing nonconforming setback by reducing the rear setback by 5 feet and the side setback by 1 foot. It requires an exceeding percentage lot by 3.7% and other relief deemed necessary. This property is located in the residential RB district. Good evening.
Good evening, Mr. Chairman and board members. My name is Hushmand Afshar from Taj Engineering, and I'm here to represent the owner and applicant of this property located at 6 South Gate. When this subdivision in this area was created in the early 1950s, all the lots in this area more or less were created of this size, which is obviously existing non-conforming of what is required with the current zone of 40,000 square foot. The family has grown. The jog in the back, as you can see, is very narrow. They require a little more living space, but unfortunately, the hardship of owning a small lot, they are facing with this requirement. The side setback is actually, the relief sought is only 0.4 feet in the front right corner. In the back, we are okay. The other hardship, if you may, that the applicant is facing is that in this case, the historical setback, rear setback, which usually is relaxed more the current setback and works in the favor of the applicant, in this case, that's not the case. The rear setback, the current rear setback is, for zoning, is 30 feet. But we were told we had to go by the historical setback, which is 35 feet. And so in order to make this addition meaningful and a little more useful, create more living space for the applicant, we extend the existing side of the building about 3 feet beyond, which is 30. That gives us 30 feet setback to the rear setback, which meets the current zoning requirement. But unfortunately, for some reason, we have to go by this historical setback, and that is where that 5-foot relief comes into play.
First time I've ever seen
the house, I mean, to my experience working in all the towns and cities in the area, usually the historical setback works in the favor of the applicant. The house is a single story, a one-story ranch. Obviously, it's a small house on a small lot. And we really have no choice. The applicant has really no choice in order to make this addition meaningful to what is proposed on this plan. For that, we request your approval. We don't believe that this is really detrimental to the neighborhood in general. The addition from the house, nearest house in the back, is over 150 feet, the corner of the addition. To the left, we are more than 100 feet to the house to our left. And to the right, which is the closest, number 8 South Gate, we are over 65 feet distance. The addition is. And the neighbor on the right, the abutter on the right, number 8, has given, which I actually received just tonight, a letter expressing their support and no objection to this addition, Mr. Chairman.
Yes, please. Thank you.
All the neighbors have received a notification. They have met with the applicants, and at this point, we'll be more than happy to answer any questions.
So it's gotta be this one.
My math tells me it's all special permit, there's no variance required.
Can I ask a question, Chairman? How do we?
Absolutely.
I might have missed this class, but how do we determine which are A1, 2, and 3?
We have a map in the office. The majority of the town seems to fall within the, A2, I believe.
The
I
RA2, right?
confirmed by looking at the map in
Okay.
the office that it fell
Looks
within
like
that.
this works.
This
We're
is,
definitely RA2.
these are
Yeah.
RA2.
Yeah.
The front doesn't, right?
Okay.
It's,
RA2.
Because I didn't see it anywhere on the plot, the plan.
Mm.
Yeah.
Front's 35, right? So
Okay.
they have 31.
35,
Well,
7.
looks like,
Okay.
20, so.
So
close
initially, we've been writing
enough.
up this legal notice, just like the other
7.9.
two
Is this the one we're
properties I
talking-
put in.
Yeah,
Yeah.
variance
we gotta
and,
be
special permit and or
35,
variance.
but
In this case,
Well,
this
within
was a
20,
little
yeah.
it's
confusing,
already
as
only
she was
this right
mentioning.
pre-existing,
Historic
Yeah.
setback is more stringent than the current
Non-conforming.
setbacks.
so we're good.
That's crazy.
I had asked Hushi to revise the plan, which he did, just to show all of the requirements as the pre-existing non-conforming
Right.
Yeah.
setbacks, because we can't list them as half conforming, half non-conforming. And then
Oh, yeah.
in reviewing the legal notices with Evan, because I usually have him look them over too before posting them, and talking with Jose, and Jose, correct me if I'm incorrect, correct me if I'm wrong here. In reviewing that a second time, we realized this too falls within the same 195-8 nonconformity, section E2, potentially, and that's what the board needs to decide, whether you want to issue it as a variance in the back, or you want to just put it all into the pre-existing non-conforming special permit.
Well, even the 20% on the rear with the 35-foot is 7 feet. So he's only 5 feet shy. So it's a special permit regardless. 20% of 35
So,
is
so we
7.
can't do
Yeah.
20% reduction on historic setbacks because it's double dipping. So the 20% reduction is for section
For lot
195-9
A.
conformity.
You can't reduce 20% on historical, because they're already getting the leeway with
With the
being granted the
historic,
historical.
right. That's why we don't,
That's why they
that's why
get
we
the
don't list
leeway
it when
to
we
give it,
issue
I
the
see.
permit, we don't issue it under that.
So, 12, 16, 28.
Yeah, the side setback is definitely a special permit.
We did submit this
Why?
plan first with respect to the current zoning, which was working in our favor, but
I'm good with that.
Okay, maybe Southgate's the front.
Yeah.
Sorry.
This is the front here.
Yep.
So side is now 16.6.
Right, and that's because that side lot line
12
is not a
28.
direct perpendicular, it's at a slight slant, and that's where you get that
I see it.
difference in the setback.
Yeah.
Okay,
Minimal difference.
So they are always non-conforming because they were
Mhm.
never at 35 front.
They're at 40 front, or the R2, 35, right,
Yeah.
right.
Which they never were.
But existing is 29, right. So they're non-conforming in that regard too.
And you can't do
All overall.
20% on a previously non-conforming, is that right?
We can't do
Right.
it on historical setbacks.
Yeah.
But we can do it on today's setbacks, and that would be exactly 5 feet. It's 25 to the rear,
Is it
right?
just the
That's
historical, or is it also that it's currently non-conforming? Does that eliminate it from the 20% as
But
well?
we don't need the 20% because we can,
You can issue it under the special.
Yeah, I'm just
permit
trying to
on the other section,
understand
but yes.
for my
Yeah.
education, the things that eliminate it. So historical setbacks, if you're using that, it eliminates the 20% rule. And if it's previous
Don't have to.
non-conforming, that
If
also
it's already
eliminates the 20% rule,
non-conforming.
correct?
Pre-existing
Right, the
non-conforming,
20%
certainly, no doubt.
reduction
Yeah.
is only for conformity.
And if
when
we
it
use
meets
the
all the setbacks.
The
grade A
current
setback of
setback.
25 feet,
But
or
that's why we
30
have that
feet.
subsection
Yeah,
E2,
E2
would be
is
better
to
than
be able
35
to
on
address the
historic.
majority of the lots in
Well,
town
we can do that.
that
There's
need,
nothing to stop us
fall
from
under
doing
the
that.
same issue.
I mean, the
Was
current
today.
setback is, the current zoning is 30 feet, I mean,
It's, yeah,
Yeah.
yeah.
and go figure, I mean.
31, that's less than
Would you
5.
like to open it up to the audience, right?
Side.
Why don't I read the letters first?
Special permit.
You
Sounds
would
like
happen
someone
to
wants to go
reside
home.
there, would you?
We got these people educated, they've been here so long, they understand
He
it.
is a lifelong resident of Chelmsford. Since 1983.
Don't rush to be in favor, take your time, think about it.
this.
Just
He
this-
graduated with my
departmental-
children
sorry,
from Chelmsford
departmental
High.
letters.
We're gonna,
Yeah, let's
we're gonna
see.
have to.
They have been paying our taxes.
Do it from non-conforming from day one.
What's your company?
I'm using my nose
It
right
should
now.
work.
I'm getting tired.
Who?
You get overtime pay pretty soon.
Gold Star.
Oh, yeah.
I thought you looked familiar.
Everybody looks familiar to you tonight.
I know, I used to drive up, we used to next to each
She's
other
going
and
for
pick
the
up in
mayor job.
Pennington all
I
the time.
think so.
I remember,
That's my business partner.
oh, okay.
Yeah.
White truck
But
with
we've
the
been
red
told-
lettering.
We've been told
Yep.
we look like brothers sometimes.
You, well, you do, well, I didn't stare a lot, but
Cookies and
definitely.
tea, we could set this up.
Sorry.
Okay, members of the board, this is from the Chelmsford Fire Department regarding the special permit request for 6 Southgate Road. This offers the following requirements and recommendations. Without the full architectural plans, no determination on smoke, heat, code detector requirements can be rendered at this time. All construction required to meet 780 CMR for detector type, location, interconnection, and power supply. All plans are required to be submitted to and reviewed by this office as part of the building permit process to ensure full compliance. I request this letter be made part of the public record and incorporated into your approval process. Sincerely, Josh Abbott, Captain, Fire Prevention Office. I have a letter from Sheila Joyce, Project Engineer, regarding 6 Southgate. The proposed addition will be near or possibly over the existing sewer service. Applicant must contact the DPW Sewer Division to coordinate any necessary actions to preserve or alter the sewer service. The application does not detail the proposed use of the addition. Further clarification will be required if approved by the DPW to determine if sewer capacity fees apply. Erosion control advisors must retain the sediment on site. These must be installed prior to any work or earth disturbance. Consideration should be made to install roof drain dry wells to the addition to keep the stormwater runoff within the property. This is not a requirement for approval. I have a letter from the Chelmsford Water District with no concerns.
Chelmsford Water District, no concern.
I have a letter from the police with no concerns regarding 6 Southgate Road. I have a letter from the treasurer collector regarding 6 Southgate Road with no concerns. I have a letter from the Board of Health for 6 Southgate Road with no concerns. That's the extent of my letters. Oops, I have one more. To the Chelmsford Zoning Board of Appeals. What lovely handwriting. We have no objection to the planned addition by Ian and Kristen McWilliams at 6 Southgate Road. We are confident that it will be an asset to the neighborhood. Donald and Ann Dean, 8 Southgate Road.
Just at how good their handwriting was.
It's
Yeah.
pretty, it's not very readable, but it's very pretty.
Pretty, but I
No,
can't read it.
they don't teach cursive, you can't.
It might even just be the
We'll let her know.
The stationery?
stationery, right,
Stationery.
right. Front and back.
Any comment?
Any questions or comments from the audience at this time?
I make a motion to close the public hearing?
Second.
Second by Stephen, all in favor?
I'd like to make a motion to approve the special permit under 195-8E2 for the construction of the addition to increase the pre-existing non-conforming at 6 Southgate Road, taking in consideration all the letters read into the record.
I second.
All in favor? Opposed? Good luck with it.
Enjoy.
Thank you very much.
Thanks for your patience.
Pays off.
I know.
Boy,
Enjoy.
do I gotta have a vote? No? That works.
We'll do minutes, let's do minutes next month.
I read the minutes, but I think
Before
I'm the
we
only one.
forget, going back to the endorsement,
Sign, yes.
Yeah.
I don't know if the board just wants to sign or actually, I don't know if you need to vote to endorse it, but I did look up the 5 voting members on the actual comprehensive permit, and they were Brian, Charlie, Jamie, Peter, and Glenn.
Okay.
Brian, Charlie,
So
Jane.
these 5.
Right here, we have
Right
to
here,
sign.
5 in a row.
What's that?
If you could all sign, there's 3 signature pages.
That's easy.
Want this one?
So if you could take a minute to do that now, just so that I don't lose them,
I did take a computer back,
please.
I agree with
because
you.
mine
Make
broke.
notes on it.
And you can sign and print your name underneath, if you wouldn't mind printing your name underneath.
Sign and print.
Yep.
Have notes on all.
All 5 copies.
She did some messy, she wrote my name already.
Of course.
3
You get a
copies.
title.
I guess my wife's not getting her potatoes too.
We'll write something
Marathon session.
down for the,
You wanna go over the notes?
Oh, what?
what he said,
Yeah,
something
minutes.
in writing for the
Oh, the minutes, yeah.
Jamie's
ADU guy
abstaining, she wants to go home.
who got
Oh.
denied.
It's only
Who got
10:30.
something in
Right.
writing for the
So I
decision.
will distribute the draft once the
Well,
attorney
next time we'll have
reviews
4
it.
minutes.
I'm unclear as to whether or not it will come back for endorsement,
I
or if
read
he
all the
will
minutes because I
sign it
thought
like
we were
we
gonna vote
normally
on
do
it.
once
Okay,
it's
because I thought
drafted.
Evan was saying
He
that
was
the
saying,
people who
So-
voted against it would,
We sign on the chart.
oh,
voice their
yes, so I'll
opinion.
email to make sure that I understand
Okay.
what all
What
the
are we signing?
reasons were
Oh, we have to
for
sign 3
rejecting
copies?
it.
I want
Yes.
to get that down before I
I'm
forget
gonna
what my
say we're
reasons.
gonna.
Write them down, or
One,
email me,
two,
or
yeah.
email me tomorrow.
Okay.
Oh, I know, he's out of his mind.
Sign the name right there.
So-
We're still in open
I
meeting.
We're still in
know,
open
but-
And then
meeting.
just print your name
Yeah,
underneath.
thank you.
But I don't have room.
Do it like they did.
So there's 3, don't,
could.
please don't sign the notary page, there's a,
Jamie
it's
put
2
her
pages, let
name
me
there
just
and
hold
printed
on.
her name. I
It's
guess
too
I did
late,
it at the same
everything has to
time.
Sign on the line and print next to name.
Please,
Yeah.
Print next to me?
yep, please.
Sign on the line and then print where it says name.
Name.
I'll just
And
print next
put your
to it.
social underneath, so we can
Right.
verify your identity.
And a
and-
Visa card if it's
Thank you, Kim.
possible.
Can we close, or we have to wait till this is finished being signed?
Mhm. Did everyone get to read the minutes?
No,
I read them for what it's worth.
There.
You did?
I was getting bored, I had to
Give you
read
the whole
some.
space.
You have pretty good
They're,
handwriting
I've got
right
plenty
there,
of
so.
work. If you need to read
My
something.
handwriting
The
stinks.
first set of minutes, June 5th,
Exhausted.
Stephen and Jamie were absent, so they wouldn't be
Yes.
voting on it.
Good.
awesome.
This,
Oh, that's you.
second set of meeting
Oh,
minutes, the
wouldn't that only
first
be
of
for
the
the voting
18th,
members, or-
Jamie
Yeah,
and
he's one of
Stephen
the
were
vo- he
also
was that night.
absent,
Oh, okay.
as
Well, I
were the
thought there was
third
5
set,
of
the
these.
second
There's 3, you
meeting
didn't sign
in-
that one,
Uh,
Sarah.
Oh, June.
Yeah, so the first 3 sets of
Notes.
minutes, Jamie and Stephen were absent, so they don't have to weigh in on that, or can't. And then the last set of meeting minutes, the only person not here was Danny, and he's not here today, so all of you can weigh in on it if you've had a chance to read them. If not, we'll,
So why don't we do the
We'll
first
hold
3
off.
Why don't we do the first 3 set of meeting minutes?
And maps,
The
too.
last.
Well, the 18th's pretty short. The 18th, no.
Oh, we only had that one thing.
There was 2 meetings
there was
on the
2 meetings on
18th.
the 18th,
But they're short.
yeah.
I'll review while you guys do the first 3.
So you weren't here.
Yeah,
You can
nothing
read them,
to
but
do.
you don't have to, you can't vote on them.
All right, all in favor if we,
Did everyone get,
tenth.
everybody else get to read the minutes to approve them?
all All in favor of approving 6-5, 6-18, and 7-10?
No, there's two 6-18s, two separate ones.
There's two separate ones,
Correct,
Brian.
Two separate ones,
Sign
two
copies.
separate
Oh, we have two
locations,
different
yeah.
locations.
So,
All in
Peter,
favor
you
of
and Jamie are gonna get fired.
6-5-25.
Oh my.
Oh, if we were there, we can vote on it.
Yes.
We were voting member that night. Okay.
correct, yep. Thank you for everyone signing these.
We're gonna approve them? Motion to approve?
Motion to
6-5-25?
Motion to
Second? By Charlie.
Okay, who did first? I'm sorry, Rod?
Rod.
Okay, Rod and Charlie, thank you.
All in favor?
Aye.
Great.
So, a motion for 6-18.
River Neck Road?
River Neck Road.
River Neck
That was a
Road.
fun night.
Yeah, fine.
I
Two
motion to
locations.
approve River Neck Road.
We have a second.
Charlie?
Yeah.
Charlie, second, or Steve Can? Second by Peter?
I'll second, yep,
Okay.
sorry.
All in
Thank
favor?
Aye.
Did they go, did Ledge Road go to court yet?
Oh, no.
They filed papers, I don't think there've been any meetings yet
No
We have a
meetings.
Second, 6-18-25,
for Ledge.
Ledge
draft
Road.
Ledge Road.
Make
Have
a motion for that.
Charlie,
I want to motion that.
second.
Okay.
Rod has got a
Rod,
You
motion.
do
Okay.
it.
Charlie can second.
Yeah.
All in
Okay.
favor?
Oh, it's the other
Aye.
way around, Rod
Yeah.
first,
Yeah.
Charlie second, sorry about that, I just wanna get it right.
Gets them all he can, right,
Vote,
Rod?
all hands went up?
All
Okay.
Yes.
Thank
I
you.
just had so much fun that night.
And then,
7-10-25, we need a motion.
I missed the first two,
Motion by Charlie, Rod for 7-25?
Charlie,
7-10, excuse me.
7-10, so last month's meeting, everyone was here except Danny. Charlie and Rod?
and I missed the first two.
All in favor?
Aye.
Did you know Ledge Road made the news on WBZ?
That's a big deal.
That's
Yeah,
a monster
from the
deal.
crowd that was there, it was a big deal.
Oh, yeah, I
I'm
don't think
so-
there was
I have to
anybody
say I'm sorry.
against us, you know.
No,
But
no.
I knew.
It's ridiculous. No truck should be going through neighborhoods.
So, before we,
A motion to adjourn?
Adjourn. I was just gonna say next meeting's
I'll go
October
with
2nd. Brian
October
won't be
2nd,
here.
motion to adjourn?
Oh, October
Jamie.
2nd, next
All
meeting,
right.
I'll be absent. Charlie's gonna take that home.
I'll try to do that.
I'll be here.
Favor?